Bail application, man. From tomorrow on.
When have you filed?
He started, man. He's 83 days already in jail custody. Is possible tomorrow?
It will automatically come tomorrow. Within 2 days. Okay.
My lord, I beg to mention.
Fine.
My lord, I beg to mention item number 19, my lord. This case, my lord, I am not pressing. The petitioner has been discharged by the court's below on receipt of the charge sheet.
Item number 19.
Yes.
Heard Mr. M.H. Rajbur Bhuya, learned counsel for the petitioner, who submits that as the petitioner has been discharged by the trial court, he has instructions to withdraw this bail application as same has become infructuous. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. This bail application is dismissed on withdrawal.
But my lord, he has been discharged. No question of it.
Good for you.
My lord, Lordship, in a mutation case, 2 accused has already been granted by Lordship. Now, in that connection, my lord, a senior ACS officer has also been called for, my lord, by virtue of issuing notice 35. Now, since my lord, he is discharging my lord, official duties, little protection is required to my lord cooperate the investigation. Lordship, I pray this matter may kindly be taken at 2 p.m. my lord. He is a senior ACS officer.
Unlisted. When have you filed?
My lord, today, my lord.
It will come in its due course.
My lord, tomorrow, my lord, if Lordship, kindly be pleased to take.
No, wait for.
My lord, otherwise, my lord, the
Only notice has been issued, 35(3) notice.
my lord, but
It indicates that there is the police do not intend to
my lord,
arrest you.
it only differ, but it does not restrain from arresting, my lord. Suppose, my
But
lord,
no urgency is there. It will come up in its due course.
by tomorrow, my lord, can.
No. If it does not get listed within 2 days, then you can mention.
My lord, you can.
My please, Lordship, for withdrawal, Lordship, tomorrow, Lordship.
Okay.
Kindly allow me to bring on record an affidavit filed in item 18.
Okay.
Much okay.
May I please, sir? I become item 39 and 40, my lord, from hearing column, my lord. With consent from the other party, my lord. Let me adjourn for the day, my lord. Fix up any date, my lord.
Next week.
39 and 40.
Yes, my lord.
Why are you seeking adjournment?
Ready today, my lord. So any day next week, any
No,
day.
no. Why are you seeking adjournment?
Yes, we are not ready. my
Not
lord.
ready. Okay.
Sorry, my lord.
Heard Mr. P.K. Bora. Heard Mr. D.
D.
Bora.
Bora, my
Learned counsel for respondent number.
39, madam.
petitioner, my lord.
40 here.
Respondent, my lord.
In 39 for the petitioner. In 40 for respondent. Who seeks adjournment on the ground of personal difficulty, his personal difficulty. Also at Mr. S. Nawaz, learned counsel for the petitioner. Respondent in 40. 40. Yes, filable. Who raises no objection to the prayer for adjournment, and the prayer is allowed. Let this matter be listed.
First week of September.
In the first week of September on a date to be fixed by registry. Registry, if it does not fix, you. No date. Registry will fix date. I am giving a week. Suppose within that week it is not listed, then you can mention.
My please, your losses, my lord, let the matter be listed tomorrow for motion, my lord.
Which matter?
This one.
When have you?
Actually, in the morning I was filed, but due to server down, I could now.
You have not yet filed.
I have already been filed. Number is there, serial number is there, my lord.
When have you filed?
8337.
What-
Yesterday morning, but due to server down, my lord,
No,
the
no.
number is not, could not be procured. My lord. That's
No.
why I mentioned for tomorrow, my lord,
No.
anticipatory bail, my lord.
It will come in its due course. If it does not get listed within 2 days of your filing, only then mention is allowed.
That rule.
You wait for 2 days. Yes,
Item
Nice.
25 of today's list, your lordship. The matter may be adjourned for the day, your lordship. My senior, Mr. Diganta Das, he had to go out of station suddenly, your lordship.
third, Mr. What is your name?
PK Sharma.
May I please, your lordship?
Understood.
I'm appealing for the prosecution, lordship. And there are some connected matters also, item number 23 to 26.
24,
20?
24, 25, 26.
23 to 26, your lordship.
What
All
the
connected
council,
with the same affair, lordship, maybe taken up on the same date.
but other council have to be informed.
I have instructed my colleague to inform Mr. Botakur.
You will inform others.
Yes.
I'm for 25.
Third, Mr.
PK Sharma.
BK Sharma, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting counsel. Learned additional special PP does not raise any objection. He also submits that he will inform the learned counsel for the petitioners of other connected cases. Considering the submissions made by learned counsels, the prayer is allowed. Let this matter be listed on 11th of September.
Okay, there is interim order that may be continued.
The interim order shall continue till next day.
Obliged, your
Obliged.
May I please, lordship, I beg to mention item number 20, the pass over for the day,
20,
20.
on request of learned counsel for the petitioner, this matter is adjourned for the day.
Interim shall be continued.
Interim order shall continue.
Obliged.
May I plead your lordship, I am praying for listing my lord. Matter 482 application, my lord, complaint case. Already, my lord, charge sheeted. I have filed that case, my 13-3, my lord, but not listed, my lord. If possible, my lord, Monday, my lord,
Monday. Monday.
my lord. Or similar, another also, my lord. That case also, I filed, my lord, 18-11, my lord, 24.
1811 till date, it is not listed.
That case, I have objection already.
Some defect was there. Okay, Monday.
I oblige it.
May I please? Lord, I beg to mention for listing of a matter, my lord, this is anticipatory bail. So may I pray for the listing of the matter, my lord, tomorrow?
When have you filed?
Lord, on 26/8. I have some urgency. The petition is
Okay.
running.
Okay.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 34. Can you adjourn, lordship? List after 3 weeks, lordship.
34.
Yes, sir. Interim is there, lordship.
If interim is there, you cannot pray for long. Case there is there. Why are you praying for adjournment?
Sure. Lordship.
Next week? Heard Miss
Here we go.
N.A. Begum, learned counsel for the petitioner who seeks an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. Learned additional public prosecutor submits that the case diary is available next week at the date. The prayer is allowed. Let
Obliged.
this matter be listed on 5th of September. The case diary shall be retained till next date.
Interim is there, lordship.
Interim order shall continue.
Obliged.
May I plead your lordship? Lordship, I pray for listing an anticipatory bail application, my lord, tomorrow, my lord.
When have you filed?
Accused has already been released on bail.
When have you filed?
It was filed on 26, my lord.
Okay.
Obliged.
May I please, lordship, I beg to mention item 22, my lord. Next week, my lord, at any date.
Why?
Which her file is missing, my lord.
Heard Mr.
22.
S.H. Sikdar, learned counsel for the petitioner who prays for an adjournment on the ground of his personal difficulty. Case diary is there. On Mr. K.K. Parashar, an additional public prosecutor, submits that case diary is available. However, considering the submissions of learned counsel for the petitioner, the prayer for adjournment is allowed. Let this matter be listed on 4th of September.
Hello.
Case diary shall be retained till next
Interim
day.
may be continued, my lord.
The interim order shall continue till next day.
Hello.
May please, Your Lord. Actually, the petitioners in this case have instructed to withdraw this case, Lordship. We have returned the brief, Lordship.
Heard, Mr. What is your name?
P.K. Basu.
Heard, Mr. P.K. Basu, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw this anticipatory bail application. The prayer is allowed. This anticipatory bail application is dismissed on withdrawal.
Okay.
May it please your lordship. Lordship, 483 bail application, your lordship, FIR, your content of the FIR is on page 15, your lordship. FIR registered under 22B and 29 of NDPS, your lordship.
22B, since when you are behind the bars?
Lordship.
Since when you are
Your
behind?
lordship, 48. So 23 days. As of
You are calling for case diary. Heard, Mr. I. Hussain, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Call for the case diary. Please,
10th of September.
please this matter on 10th of September.
Well, final complaint has been filed, my lord. LCR will be confirmed.
Heard Mr. N.N.B. Chaudhary, learned counsel for the petitioner. Also heard Mr. A.K. Jain, K. Jain, learned counsel for NCB. Let the scanned copy of the trial court records be called for. Let this matter be listed on 15th of September.
May it please your lordship. Your lordship, the child in conflict with law has been apprehended on 3/7/25, my lord. And he has been in judicial home till now, my lord. Lordship, may kindly see the FIR on page 15, my lord.
You have not moved the application
Yes,
for bail
lordship, yes, lordship. Lordship,
before
may kindly
JJB.
see, page number 23, the relevant page is 24. Page 24, my lord. You know, the exception of section 12 of the JJ is missing, my lord, while passing the order. The three principles, my lord, that are missing perhaps. My lord.
You are in the observation home now.
Yes, yes, my lord. Since then, my lord, 3/7/25.
Yes. We'll call for the case diary. What is the offense?
My lord, offense is, my lord, section 302 is there, my lord.
Now
My lord,
on
the
the
witchcraft, my lord, is there, my lord.
7 and
Which I
5 of
think 7 and
continue.
5. my lord.
5 is, my lord, resulting to death, then shall be punished in accordance with 302. Or similar to 30, now 103.
Heard Mr. T. Kolita, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the case diary be called for. Let also the scan copy of case record of Dokmoka PS case number 19/2025 be called for from the Juvenile Justice Board, Karbi Anglong. Registry to take steps for requisitioning the scan copy. learned additional public prosecutor shall produce the case diary. Let this matter be listed. 15,
May I pray for a short date, my lord?
suggest
11, 10 or 11.
11. 11th.
Much.
And then 4.
I please your This is the 483 daily application, my lord. The petitioners are behind by for 2 months, 27 days. The case is registered under sections of NDPS. So, case diary may be-
NDPS Act section,
Commercial.
22C, 25.
it is pending investigation.
After investigation.
Heard Mr.
SS Ahmed.
S.S. Ahmed, learned counsel for the petitioner, also heard Mr. K.K. Parashar. Call for the case diary. Let the-
17 September. my lord.
Let this matter be listed on 17th September.
Item 5.
My lord. Subsequent matter lordship, sir. It was behind the whole last 126 days.
What is the matter?
Proxo, my lord,
Proxo matter.
notice and scan copy, my lord.
Heard Mr. M. Hawk, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned the additional public prosecutors. Let the scanned copy of the trial court records be called for. Let also notice be issued to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in person to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 17th September.
I'll give us short that, I'll 15 order exam, my lord.
September.
I'm up.
6.
Actually, it is a case of cyber fraud. At this stage, CD may be called for.
Heard Miss
Excellent.
S. Rahman,
Shorted me to give.
learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Let the case diary be called for.
Okay, this is forwarding on 7/8. Let us 15.
15th September.
Item 7.
Transited matter, petitioner number 1 behind the bar 406 days, my lord. My lord, other similar situated
What is the matter?
affair is page 12, my lord.
Offense is under which?
Arms side. Children, a murder, my lord. But other, all or other similar situated person granted bail, my lord, by this honorable court, my lord. At the time of my lord, arrest, my lord, grounds of arrest, my lord, not punishing the petitioner.
Okay.
My lord,
Heard
out of
Mr. Z. Hussain,
my lord.
M. Hawk, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. Let the scanned copy of the trial court records as well as the scanned copy of the connected case diary be called for from the trial court. Registry to take steps for requisitioning the scanned copy. Let this case be listed on 16/9.
What date, my lord, all other accused
We
persons
don't
granted
have
bail, my
short
lord.
date. 16/9.
Item 8.
May I please your lordship? Lordship, it's a NDPS matter, lordship, commercial property, lordship. Case diary may call for it.
Heard Ms. Annie Begum, learned counsel for the petitioner. Also heard Mr. K.K. Parashar. Call for the case diary. Let this matter be listed.
17 September.
17 September,
18.
It's 80
18 September.
9.
of license.
May I please, Lordship, kindly the matter be passed over for timing, Lordship. Senior counsel is on leg in court number 1.
Yes, mistake.
Okay,
For timing only.
for timing, lordship.
No, it is coming for the first time.
Yes, sir, Lordship.
It is pending investigation. Pending investigation.
For timing, leadership, senior counsel is on leave in court number 1.
Okay.
APM. Your lordship, what's your proxy is there, lordship?
Also is there. Heard Mr.
M along.
M. Alam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Call for the, it is a pending investigation.
Yes, sir.
Call for the case diary and also issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 16.
Highly obliged, lordship.
May I please, Lordship. In this case, your Lordship, initially the petitioner was arrested and accordingly the release on bail. After charge sheet, the case started the trial proceeding. In the meantime, the accused person was arrested as per NBW issued by the learned court below.
You
So-
defaulted.
After receiving the summon, but he doesn't know the legal procedure and consequence about non-appearance of the court. And also, the said police station delivered the summon to the accused petitioner by saying that this notice is kept
When you were arrested.
your lordships 19/7/2025, as on today 38 days behind the bar. So if you find page number 20,
How much is the contraband?
contraband 22B, trial is going on.
No, how much is, what is the contraband?
Contraband, your lordship, as per charge sheet, you find page number 16 that 304 contraband capsule. 304
What capsule?
spas terosians plus
Another.
and spas plus. So earlier he was released on bail, thereafter NBW was issued. Three occasions he was not APR due to lack of knowledge. of
Where is the rejection order after?
rejection at the, yes. That you find 26. This is the second time bail application, your lordship, 26 page. And next date fixed for 15/9/2025. So any condition may be imposed, trial is going on, I will forward the trial proceeding. Any condition, 38 days. Earlier he was arrested, thereafter due to lack of knowledge. He was not APR.
What lack of knowledge?
So
Since February, 27 to election.
the occasion he was not present. And because
27 to 5 and 21/6.
I have stated one paragraph 8. My petition. 38
Yes,
days,
Mr.
38 days.
Parashar. Let him appear.
Civil condition.
Heard,
Trial should go.
heard Mr.
Yes,
S. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Amir Hussain, who has been detained behind the bars since 19/7/2025, within bracket for last 38 days in connection with NDPS case number 26/2024, pending before the Court of Learned
Special Judge Nalbari.
Special Judge Nalbari. Learned counsel for the petitioner has submitted that the petitioner was allowed to go on bail during, where is that bail order?
Bail order I have not annexed.
Where
Sorry,
where
I
is
have
the
listed-
statement
Yeah, para number 3. Bottom part.
was allowed to go on bail during the investigation, during the pendency of the investigation, and pendency of the investigation. However, later on, charge sheet was laid against the petitioner in the above mentioned case under section 22B2, 22B of the NDPS Act. Learned counsel for the petitioner has submitted that though the petitioner received summons from the trial court, however, due to some misunderstanding, he could not appear before the trial court on the date fixed for appearance, and therefore trial court issued non-bailable warrant of arrest. And for last 38 days, he has been detained behind the bars. Learned counsel for the petitioner submits that the petitioner is ready to face trial. Where do you stay?
Your lordship,
You-
under PS Mukalma Kaplaburi,
Nalbari district.
Nalbari district.
And he is the permanent resident of Nalbari district. Stop. Mr. Parashar, you have any submission?
Reading appearance, but no absence subsequently.
On perusal of the records, it appears that the petitioner defaulted in appearing before the trial court on
27 to
three
3 appearance.
consecutive dates. However, considering the submissions made by learned counsel for the petitioner, that the petitioner did not appear before the trial court due to some misunderstanding, and he is now ready to face trial. This court is of considered opinion that his custodial detention may not be necessary for fair completion of the trial if he cooperates in the trial. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned special judge Nalbari with following conditions. Condition number 1 into trial condition. This bail application is accordingly disposed of.
Obliged. 12.
Yes.
May I please, your lordship, the petitioner was arrested on 27/6/2025. This is the case under section 6.
Oxo
Yeah, also is there, your lordship.
will issue notice. Heard Mr. M.K. Shah, learned counsel for the petitioner, also heard Mr. K.K. Parashar. All call for the case diary and issue notice to respondent number 2. The petitioner shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on 16/9.
Kindly take a short date because this Fatasila number placed very nearby.
Notice has to be take some time from the. registry also.
16/9,
Lordship.
list accordingly.
That's good.
May I please, Your Honor? On last occasion, Your Honor, instruction was to be taken, whether search is submitted or not.
No,
Today is
such is not
9.
yet submitted, Malad, case there, Malad, maybe taken after some time in the bail hearing, Malad. Though it is a motion, Malad,
I am behind the bar since 90 days, Lordship. I was-
matter, Malad, 43 also, Malad. Today.
90 days. If charge sheet is not submitted, then he is entitled to get bail. We will take up other matters when the matters are called. Heard Miss, what is your name? Heard Miss P. Kolita, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, Learned, Additional Public Prosecutor. This application under section 483 of BNSS 2023 has been filed by the petitioner, namely Hassan Basri, who is in connection with Musalpur PS case number 38/2025 under section 316 within bracket 5/3 of BNS read with section 66C/66D of the IT. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 90 days. And in this case, the maximum period of detention which statutes prescribes under section 487 of BNSS is 90 days. Hence, she prays that the petitioner may be allowed to go on bail. On the other hand, learned additional public prosecutor also submits that petitioner has been detained behind the bars for last 90 days and charge sheet has not yet been filed.
Forwarded on my lord, 1/6. 1/6 calculated, my lord, 89 days.
He also submits that though the petitioner was arrested on 31/5, however, he was forwarded to judicial custody on 1/6/2025, and therefore today is the 89th day of his detention. Stop. I have considered the submissions made by, what is the progress in the investigation?
The bank manager was recently arrested, so investigation in that regard is still going on.
As regards the present petitioner,
Present petitioner also already sufficient materials are there. So
okay. And
On length of.
on perusal of the case diary, it appears that there are sufficient incriminating materials against the present petitioner in the case diary. However, considering the fact that the petitioner has been detained behind the bars for last 89 days, his further custodial detention does not appear to be necessary if he continues to cooperate in the investigation. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned Chief Judicial Magistrate Baksa with following conditions, number 1 and 2. This bail application is accordingly disposed of.
43, so far, the date of detention is concerned, nowadays, it is Supreme Court already held from the date of effective order, not from the date of forwarding. That has to be counted from the date of arrest. Right now, I don't have, because established law.
No, whenever you submit, you have to.
Yes, of course, today, as also already granted the other.
Since how many days?
31/5, same.
Same.
Then also 90 days.
90
Not
days.
not
90 days.
completed 90. They will done
Same
with
order.
equal well.
Same order, name of the petitioner will be different.
item 44.
May I please? It's an anticipatory bail, my lord. Lordship will kindly come to page 17, my lord. Lord, I am a teacher. And on that particular day, this informant's daughter, she was also in the, when I have gone to take my medicine, I met her inside the pharmacy. Then I have asked her about her studies and all these things. Then this is the allegation has come up in the page 19. First of
Page number?
Page 19.
19 is the FIR.
Not, it's a first complaint to the principal, my lord. I am the teacher of that particular school, and as well as the alleged victim also belongs to that school, my lord. This is the first complaint that at 5:30, I tried to,
Case diary would be required.
Notice and
and then Lordship can see the next part, page 21, why the FIR has been lodged. Page 21, Varnical version. They have demanded 6 lakhs of rupees from me. On that, they have come into a decision, Alusonar Siddhanta and Shorta. Lordship kindly see. ছোৱালীজনীক উচিত পৰিমাণৰ ক্ষতিপূৰণ দিব লাগিব, minimum 6 lakhs. Then স্কুলৰ পৰা বদলি, that's যদি উক্ত 1 and 2 শর্ত দুটা মানি নললে আইনৰ ব্যৱস্থা লোৱা হয়. And then the FIR has been.
No, but who has demanded money? Deputy.
They have demanded one, they have signed it, my lord. Principal and the other.
But principal is the, where is the FIR?
FIR at the page, my lord, 11. Rahana Akhtar.
mother is the
Mother is,
Yes, and Rahana Akhtar lodged this complaint, my lord, to the principal. Page 17. Rahana Akhtar subsequently lodged this FIR. Initially, she lodged the complaint to the
but
principal.
Rahana Akhtar has not demanded any money from you.
No, she signed it, my lord. Page 19. He is the complainant in page 19.
No,
On the basis of her complaint, this is the resolution has been taken. That if I don't pay the 6 lakhs, then no
no,
complaint.
that is the demand by other people, not
On
by,
the basis of the Rahana's, my lord, application.
case diary would be required. Heard Mr. A. M. Bora, learned senior counsel, assisted by Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. K. K. Parashar. Let the case diary be called for.
notice also.
Also issued, let notice be also issued to respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 in pursuant to the prevailing notification of the registry in this regard within 3 days from the date of this order, returnable on
Not date, my lord.
11th.
May it please your lordship. My lord, the petitioner before your lordship, my lord, he's a lawyer, my lord, and secretary of the Tinsukia Bar Association. Now, what had happened, my lord, this respondent number 4, she is an intern, my lord. She is yet to get her license, and she was, caught, my lord, practicing. In fact, there are informations and materials to suggest that she is practicing. Now, my lord, we filed, there was a meeting of the association. In that meeting, my lord, a decision was taken whereby, my lord, the secretary of the Bar Association was rather directed to initiate a criminal proceeding. And that is again based on my lord, notification issued by the Bar
Initiate a
Council.
what proceeding?
Yeah.
Criminal proceeding.
Yes. If your lordship should kindly come to page 36, my lord. That is the directive of the Bar Council. If your lordship should kindly come to the last para at page 36.
Yes.
Further, some members have stated that many persons who have passed law degree but yet to be enrolled under the council are attending courts wearing black band and black coat, and on occasion are appearing in court. the Secretary of the Bar Association is requested to take up the matter with the respective Bar Association so that members become cautious, and in event they find anyone appearing in court without getting enrollment, wearing band and black coat, necessary action be taken against them by filing ezahar before the police station, intimating to this council so that this council can also take up proper action. So there is a mandate from the Bar Council, my lord. If anybody is found to be practicing without a license, then an ezahar should be filed before the police. Pursuant to this, my lord, there was a meeting of the Bar Council, my lord, which your lordships will get at page 41.
Bar Association.
Yes, my lord, Bar Association, page 41. Please come to 3, my lord. The executive committee, after a threadbare discussion of the subject and considering the gravity of the matter as well as to maintain dignity and purity of the profession and discipline in the bar, as well as unanimously resolved that as follows. It is unanimously resolved that an effort is to be lodged against Anisha Mannan, the associate of Sri Munna Kumar Singh, for unapologetic illegal act committed by her in the last few weeks. Accordingly, Biswajit Prasad, that is the petitioner before Secretary General, Tinsukia Bar Association, authorized to file FIR against this so-and-so. So pursuant to this, my lord, a FIR was filed, which your lordships will get at page number 47. And the relevant is at page 49, my lord. At page 49, with reference to the subject cited above, this is to bring to your notice that one lady, Miss Anisha Mannan of Philobari, and associate of Advocate Munna Singh of Tinsukia Bar Association, is found practicing in Tinsukia court without having a valid license. Today at about 12:56 p.m., she was found dressed in advocate attire with band in the court of the Honorable District and Session Judge Tinsukia. While I asked her in front of few learned members of our bar about her identity and license to practice as an advocate, she confessed that she does not possess a valid license to practice, and she is an associate of the Advocate Munna Singh. It was later known to us that she is from Philobari and presently residing at Hazarika PG so-and-so. Further on inquiry, it is also found that she has been appearing in different cases in different courts and obtain orders, more particularly in maintenance case number so-and-so, in the court of the learned JMFC so-and-so, and so-and-so pending in the court of the additional CGM. Her appearance as an advocate in court is also confirmed by the learned Special Public Prosecutor B.L. Agarwal and Amarjyoti Thakuria, learned Assistant Public Prosecutor. She has also appeared in many other cases in different courts of Tinsukia, impersonating as an advocate, a photograph, etc., etc. So, my lord, based on this, at page 50, Tinsukia PS case number 293 of 25 under section 3184 BNS has been registered.
Okay.
Yes. Now, my lord, as a counter blast, my lord, she has filed an FIR, which your lordships will get at page 57. To officer in charge, Tinsukia Police Station, respected sir, I am a law graduate holding an LLB degree from Dibrugarh University. On 18/1/25, I applied for my enrollment as an advocate before the Bar Council of Assam, Nagaland, etc. I am undergoing internship under Advocate Munna Kumar Singh. The accused Biswajit Prasad, Advocate Secretary General of Tinsukia Bar, has been following and observing me inside and outside the court premises without any valid reason for last 1 month. Further, he was found loitering near my rented residence on multiple occasions, which is situated at Borguri near ITI, filed Tinsukia, and attempting to contact me repeatedly despite my clear refusal, which is amounting to stalking. That on 8/8/25 at about 1 p.m. while I was standing with other advocates in premises of the Honorable District and Session Judge Tinsukia, accused secretly clicked my photograph without consent. When I objected, he became aggressive and questioned my presence in the court without advocate's license. And despite my clarification that I am only an intern, he criminally intimidated me by saying, मैं देखता हूँ कैसे तुम्हारा जैसा शेड्यूल कास्ट का लड़की एडवोकेट बनता है, मैं तुम्हारा कैरियर खत्म कर दूंगा. This was said publicly in front of several advocates and clients, causing me severe humiliation, mental trauma, and injury to my etc. etc. So, my lord, she has also invoked that 1989 Act, atrocities against SCST. So, my lord, based on this, at page 58, Tinsukia PS case number, my lord, 78 of 351 under BNS section 313, read with section 31S of the that 89 Act has been registered.
What is the offense? 31R and 31S.
My lord, these are, I think, showing disrespect to, my lord, scheduled caste and scheduled tribe. Section 31R, my lord. এখন দেখ দিব না এই schedule caste আছে না 31 কি আছে intentionally insults or intimidates with intent to humiliate a member of scheduled caste or scheduled tribe in any place with public view, abuses any member of a scheduled caste or scheduled tribe by caste, name in any place within public view. Lord, there are certain subsequent developments which are more important, my lord. Now, if the lordship now comes to page 66, my lord. This is a part of the proceedings of the Tinsukia Bar Association, Miller, on 10/8/25. Please come to Miller, paragraph 2. It is hereby resolved that both Miss Anisha Malla and Anisha Mannan, the accused in Tinsukia PS case number, and her senior, Munna Kumar Singh, have tendered their written unconditional apology, stating that they have committed wrongs and brought disrepute to the bar, as well as they do not want to proceed with the Tinsukia PS case number so-and-so. And the executive committee, after discussing the same, has accepted the said apology, and bar shall not proceed further in Tinsukia PS case number so-and-so. Both the sides shall file necessary letter petition respectively as early as possible to competent authority to do the needful for closure of the cases referred above. That means, my lord, there was a consensus arrived at in the course of the meeting where they agreed that both sides will withdraw the cases. Now, if your lordship would kindly come to, my lord, page 68. This is an apology letter written by, my lord, the respondent number 4. I'll have your lordship's attention to the page 2 part, the last subpara. Further, due to intervention of well-wishers, mutual friends, and respected members of the bar, I hereby resolve our misunderstanding and disputes, and I agree to put an end to affair dated so-and-so in the spirit of harmony in order to maintain cordial professional social relations. I do not wish to further proceed against Biswajit Prasad, Secretary, etc. etc. But this is how the matter stands, my lord. If in a criminal case, my lord, she does not depose, then what would be the fate of the proceedings? I'll humbly pray, my lord, till such time she appears before this honorable court, my lord. Lordships will.
Why a petition under 226?
226 or 482, my lord, there is, I think Supreme Court says both can be done. I don't think there is any problem with that, my lord. I think right from, my lord, Sapan Kumar Saha's case, whenever, my lord, any reference is made, quashing of a criminal proceeding, Supreme Court always says either under 226 or under earlier 482, now it is
528.
520.
Yes, Mr. Nath.
Whether
Whether 226 lies.
226, I have the objection as regard maintainability of this petition, because kindly the FIR at page 57 lordship has seen the ground of challenge kindly similar to what
Page,
what the para 23 and 24.
page number,
Page number 18. Page number 18. Well, when the projection of the petitioner is that this is a false FIR and that has to be and accordingly petitioner has prayed for quashing. Now, this is the statement of the petitioner, my lord, the para 23. Petitioner states that as regards section 31R and 31S of the SCST Act 1989, the settled law requires that the alleged act must be committed on the ground that the victim belongs to a scheduled caste or scheduled tribe. In the instant case, neither the petitioner nor the entire executive committee of the Tinsukia Bar Association were aware that the respondent number 4's actual surname or caste at the relevant time, and the incident in question did not occur on account of her caste. Without prejudice, petitioner said that even otherwise, as per scheduled caste list of state of Assam, Malla caste is not enlisted as scheduled caste. Furthermore, the respondent number 4 is a Hindi-speaking girl, and her forefathers originally hailed from Deoria, Uttar Pradesh, where the caste Malla is listed as in other backward class. The allegation are thus devoid of the essential statutory ingredients, and no offense under the Act of 1989 is made out against the petitioner. So he and kindly come to para 24 also, my lord. Now para 24, same page, my lord, para 24.
yes.
The petitioner states that the respondent number 4's forefathers originally hailed from Deoria, Uttar Pradesh, where the caste Malla is enlisted as OBC. The petitioner, through his brother, Mr. Naresh Prasad, obtained the family details of the respondent number 4 from Gram Panchayat, Mahal Manjaria Block Lar, Deoria, Uttar Pradesh, and village headman issued a family tree as well as the certificate to the effect that the forefathers of the respondent number 4, including her grandfather, belong to Mallah community, and the same is a OBC in the state of Uttar Pradesh, and therefore the respondent number 4 is also an OBC, not SC, and the SC certificate obtained by the respondent number 4 is obtained by playing fraud and misleading the authorities, and therefore the said aspect is required to be investigated properly. Well, my respectful submission before the honorable court is that this petition has been filed for quashing of the FIR, projecting that she doesn't belong to SC, scheduled caste, and the scheduled caste certificate has been obtained by her as fraud. That is the statement made in the writ petition before the honorable court. But my respectful submission is at this stage, she is holding a SC certificate, and she has the FIR lordship has seen, the certificate has been produced before the authority. But this FIR cannot be quashed when the petitioner has alleged that the certificate is fraud.
She's appearing for whom? He's appearing for.
Well, if lordship kindly comes to page 105, this is a 226 petition, sir.
Yes.
105, kindly see, page number 105. Page 105. Well, he has applied for pre-arrest bail. Pre-arrest bail, the para 40, these 3 paragraphs are important, my lord.
What is this? This
This
order?
This is the order of the order. The order starts at it starts at page number 83, my lord. Annexure 19 by additional session judge FTC Tinsukia. There will an application under 482 of BNSS was filed, praying for pre-arrest bail. While deciding that petition, kindly see para 40 relevant is 105, my lord.
Yes.
Para 40. In consideration of the arguments, same argument was made before that court. In consideration of the arguments put forth by the learned counsel representing the petitioner, this court has undertaken a thorough analysis of the entire case along with the applicable legal provisions. The court notes that the Azahar filed on August 8, 2025 identifies the victim as Manan. This designation does not align with the petitioner's knowledge concerning the victim's case status. As the allegation made by the victim explicitly referred to her caste, and the incident is alleged to have been occurred on the same date. Additionally, the statement made by the petitioner directly pertained to the victim's caste, indicating that the accused possessed knowledge about the victim's caste. It is important to emphasize that the presumption of an offense as stipulated in section 8C of the relevant act arises during the trial proceeding. Therefore, this presumption cannot be determined in the context of assessing the maintainability of the bill application at this stage. The defense counsel so-and-so, the accused asserted that the general secretary of the so-and-so requested the availability of the CCTV footage from the corridor where the alleged incident occurred, suggesting that such a request for evidence indicates the absence of any ill motive on the part of the accused. This court has thoroughly examined the arguments presented by the defense.
But I'm
and
sorry
and
to
has
interject, my lord.
concluded.
My learned friend is reading an order whereby my anticipatory bail application was held to be not maintained. I have not argued that point, my lord. Yes, because in that act there is a provision. The offenses under this act, anticipatory bail does not lie. But there again, my lord, there is a question of interpretation depending upon the facts of each case, because by the later judgment, that strict rigors has been, my lord, rendered nugatory. Now it is said in an appropriate case it can be. But I am not arguing an anticipatory bail application that my learned friend is reading that. That is neither here nor there.
Let him complete his
Yes.
submission.
Well, I am just trying to show that the materials are there and what the honorable court while examining the material has found. That is what I want to refer to. And from their petition only I am reading. Para 43. The court further notes that the allegations set forth in the victim's ejaha reflect both the knowledge and motive associated with the accused. In light of these considerations, this court finds no justification based on or justifiable basis to accept the argument proposed by the defense. Kindly, Malad, come to the para 44. What is the allegation? It is reflected in the FIR that has been quoted.
No, that has been read. Is there is a bar in the act
Yes.
Yes.
regarding anticipatory bail.
Anticipatory bail, there is a bar and they have accepted that this order was passed, that this is not maintainable under section 18 of the act. And accordingly, they have also not paid for anticipatory bail here and they have come for quashing of the FIR under 226. Let me place, Malad. The para 44, that contention of the allegation of the what is in the FIR that has been noted. And regarding the statement allegedly made by the accused petitioner, the court observes that the utterance may dekta ho so and so, already my learned senior has read, Malad, revealed a troubling awareness of the victim's caste status. This statement was made within the explicit intention to humiliate and intimidate the victim by referring her caste identity. Such a remark not only reflects a prejudiced mindset, but
No,
also
but
serves
he
a-
has not taken the plea that I don't know the caste before this court.
That is why, my lord, I have read para 23 and 24. Now, while coming before the honorable court, he has taken a stand that the caste certificate which she possesses is a fraud, is a fraudulent document. Therefore, the FIR needs to be quashed. That is his case. That is why, my lord, I have read para 23 and 24 first to show that this is the projection made before the honorable court that her caste, which originally belongs to UP, is a OBC, and therefore the SC certificate she is holding is a fraudulent document. Is para 24. This is the case projection made by the petitioner, and therefore, at this stage, my lord, kindly let me read para 45 also.
Okay. One query is whether the offense under section 3 are
And S.
compoundable offense.
Lord, to that, my lord, the apology letter has been read. My lord, kindly, that is why, my lord, para 45 I want to read, because under 183 this statement has been recorded by her statement was recorded under section 183 of BNSS.
Yes.
On 11/8. That unconditional apology letter, as I believe, my lord, on page 62 is on 10th of August. 10th of August, my lord. It was a Sunday. 10th of August is a Sunday, my lord. And para 45 at page 107, Lordship will see, furthermore, the victim's statement recorded under section 183 of BNSS during the investigation as indicated in the case diary aligned consistently with the allegations articulated in the first information report. So under what condition that under unconditional apology was there, or in a meeting of the bar, it was recorded and it was submitted, but on the second day, on the next day, before the 183 statement was recorded, she maintained that allegation. So where in that circumstances, my lord, whether the investigation needs to be done, it has to be proceed, or a case under that atrocities of SCST Act, it is made out or not? Because the prime contention of the petitioner is that she doesn't belong to SC. And the second contention is that it has been already settled, unconditional apology, and they have agreed to withdraw. But on the next day, 183 statement has been recorded before the authority, before the court. So based on the allegation, the honorable court has recorded, based on the allegation.
So what is your submission?
My submission is not, number one, the maintainability of the petition is not maintainable. That is number one. And Malad,
Why it is not maintainable?
Malad, this is not basically the FIR on the ground of fraudulent caste certificate that she doesn't belong to that particular caste, and she presumed to be, she had obtained a fraud certificate, and now claiming herself to be a scheduled caste, this FIR has been lost, and therefore the FIR itself is liable to be satisfied. That is the case for it. Malad, the materials so far available on record, the honorable court has examined, and the 183 statement recorded on 11/8, and the other materials, that shows that a case is made out under section 3(1) R and S. So investigation in this case is required, Malad, and he is evading the investigation.
No, you are submitting from the records that she might not have tendered apology and might have been forced to do so.
Maybe, because.
But unless she appears, how will we know?
Only I am referring, Manoj, because
He is holding the plea for the stay.
yes,
He's not
yes,
holding plea for the levy.
absolutely, Manoj. From the record only, because this 183 statement was recorded on 11/8, and the unconditional apology
Yes.
on 10/8. So if she has given an unconditional apology on 10/8, that is a Sunday.
She
in
would
a
not have,
period,
she would not have stated.
stated in 183.
Okay.
So that is why, my lord, my submission is that she has maintained the allegation in the FIR as well as the statement in the 183. So that much I can submit.
Where is 183 statement?
141, para 45 at
The
107.
observation of the
Quote below.
session,
Yes.
additional session
Yes.
judge.
From there only I have, well, the court has said that the victim statement recorded under section 183 of the BNSS during the investigation as indicated in the case diary align consistently with the allegations articulated in the first information report. Based on these allegations, the court identifies prima facie evidence of the alleged
No, but
offences
to
against the-
appreciate this, we must have 183 before us.
I'll-
Because she might have told that what has happened on that day.
I'll-
Because apology is a later in course.
No, apology is prior.
No,
On 10/8.
after the incident, she tendered apology. So what she had stated in 183,
That-
unless we peruse it,
If that is required for honorable court's perusal, my lord, I have to, or.
what interim relief you are seeking?
I'm just clarifying two things, my lord.
Anything else, Mr.
My
Nath?
lord, regarding
Anything else you want to submit?
Lordship wants to see the 183. I'll definitely place it, my lord. My lord, from the IO investigating authority, my lord, I have spoken what is, my lord. Subsequently, in record, they have stated, my lord, definitely when the record is called for, that I'll please. Subsequently, my lord, some developments are there that
our case.
the petitioner is putting pressure on the, some disturbances is created by the petitioner. My lord. It is on record. And she has submitted an application before the police authority seeking for protection because of some disturbances from the petitioner. So those are also there. I'll produce, Lordship may give me 3-4 days time. I'll produce the record. The
My
case
lord,
diary.
will kindly have the
And-
judgment, my lord.
And till then, my lord, question of interim may not be considered at this stage. Let me place it.
Anyway, my lord, will-
When will you be able to place
My lord, it is
the
on-
case diary?
Today is Wednesday, my lord. I can produce it on Monday or
my
Tuesday.
lord, police have already approached the court for issuing a warrant. My lord, why I am in 226, that also I'll say, but before that, please have that, my lord, judgment of, my lord,
Bhajan Lal.
Bhajan Lal, please have my lord, para 105, it is dilen niki. Page 105, my lord. In the backdrop of interpretation of various relevant provisions of the code under chapter 14 and of the principles of law enunciated by this code, in a series of decisions relating to exercise of extraordinary power under 226 or inherent power under 482 of the code, which we have extracted and reproduced above, we give the following direction. So, my lord, even I think even prior to this was the Sapan Saha's judgment, Sansaita's case.
Okay.
So all throughout Supreme Court has said, my lord, that when it comes to quashing, it could be either under 226 and or under 482. Now, my lord, why we have approached in 226? Because the IO is not examining the eyewitnesses who are present in the scene. And now, my lord, they have applied before the trial court.
Eyewitnesses, when the allegation is that you threatened her.
Yes. Page 81, my lord, we have stated that. Kindly see, my lord, page 81. Please come to, my lord, second subpara. This said Tinsukia PS case number 293 of 25 has been endorsed to SI Nurtaz Ali, who has already recorded statement of witnesses who were present in the place of occurrence at the relevant time, namely Mr. Ashok Kumar Choube, advocate, Kishore Giri, advocate Navokishore Sharma. However, investigating officer of Tinsukia PS case number 294 of 25 has neither visited the place of occurrence nor contacted any of the aforesaid witnesses to record their statement for verifying the genuinity of the allegations made in the said case. This my learned friend doesn't notice. And he is reading that order whereby, my lord, maintainability of anticipatory bail application was considered. My lord, yes, there is a bar in the statute, therefore it's not maintainable. But then Supreme Court has read down the provision to some extent, my lord. Now the issue is, the lady has already, my lord, expressed her apology and she has said she is not going to proceed with it. Why state is so interested, my lord?
No, state has some material
What material, my lord?
that the order of the additional district judge.
And kindly come to, my lord, page 106, the bail order.
This is what he's read. He's relying on
Please come to page 106, my lord, para 42.
Yes.
The defense counsel for the accused asserted the General Secretary of Tinsukia Bar Association requested the availability of CCTV footage from the corridor where the alleged incident occurred, suggesting that such a request for evidence indicates the absence of any ill motive on the part of the accused. This court has thoroughly examined the argument presented by defense and has concluded that to date, investigating officer has not acquired any CCTV footage pertaining to the alleged incident.
This was 20th August.
And this was 28-25.
8th August is the incident.
And the incident is of 8-8. Police is absolutely biased, my lord. That's why we are before our lordships in 226. And my lord, going by the FIR, is it not evident that it is drafted by a lawyer? Therefore, what Supreme Court says in such cases, my lord, Supreme Court says you must look at the attending facts and circumstances. Don't go by the per se, by the what is stated in the content of the FIR. Because often, my lord, when a lawyer is involved, then they can always, bring in the
But the victim herself is a law graduate. Victim is a law.
True. But is it not a case, my lord, where one Munna Singh is assisting her, and how come that Munna Singh has permitted her to appear in a court without being an advocate, my lord? Are these things to be ignored?
Well, we are absolutely.
Anyway, you'll get your turn, please wait.
We are absolutely.
So therefore, my humble submission is, my lord, because they have moved the trial court for issuance of warrant, I need some protection. And I am, my lord, I am not going to run away, my lord. I am the secretary of the bar. I am a leading practitioner of Tinsukia, my lord.
Where is that statement that?
Yes.
Paragraph 1.
Paragraph 1, my lord. 30 years of practice, para one.
No, no, not practice that. They have approached the trial court for issuance of warrant.
Yesterday, Mila. Yes.
What is the punishment for 3R and 3S?
6 months to 5 years.
Okay, whether warrant is necessary to arrest?
Normally, it should not be. Shall be punishable for a term which may not be less than 6 months and which may extend to 5 years and with fine.
This is the petition which is given by the police.
Now, if your lordship would kindly come to page,
It is not unnumbered.
sorry, it's unnumbered, 6, Miller. With reference to the subject cited above, I have the honor to report that investigation has revealed involvement of accused Biswajit Prasad, so-and-so into whose case, whose interim bill has already been cancelled by the Honorable Session Judge. It is not a cancellation on merit, my lord. Petition was held to be not maintainable. A charge was conducted.
We are issuing notice during period of notice. You cooperate in the
I'll cooperate.
investigation. We are not,
Yes, we'll cooperate, 100%.
yes,
But only thing is, they will not take us into custody.
yes.
I am appearing for approval 4.
Counter number 4 is there.
Yes, I filed a work number today. So
Okay.
what happened in this case? That anticipatory bail, bar of anticipatory bail under section 18 of the SCST Act. It is not absolute, lordship. Supreme Court, the Honorable Supreme Court has held in the cabinet of decision. If there is no prima facie case, the court can grant anticipatory bail, lordship.
Yes, yes.
Another thing is that what cannot be done directly, can we do it indirectly? Because lordship, anticipatory bail, the learned session judge has told that the anticipatory bail is not maintainable in view of the bar. And lordship, learned session judge has also come to the finding that prima facie material is there. So by taking those extensive hearing for 3 days, by an elaborate order, his prayer for anticipatory bail was rejected. Thereafter, lordship, what happened? One learned senior friend is emphasizing on the point that their parties have compromised. But lordship may kindly see page number, lordship, 77 for a moment. This is lordship after that compromise, lordship, that alleged compromise in the bar association office, lordship. 12/8/2025, a letter was issued by the petitioner, present petitioner, to the chairman of the bar council. Both the parties actually, lordship, in that lordship resolution, they have amicably settled, and both the parties will not pursue the criminal cases, lordship. And they will take lordship step for lordship withdrawal subsequent. This letter was issued subsequently on 12/8. Lordship, you kindly see paragraph page 79. Last part. This is issued by the petitioner Biswajit Prasad in his capacity as Secretary General. Lordship, you kindly see last paragraph. I therefore request your good office to take cognizance of this matter, cause an inquiry into the enrollment status, and court appearances of MS Anisha Malla, the victim, examine the role played by Advocate Munna Kumar Singh in the events that have transpired, and take such action as may be necessary to protect members of the profession from retaliatory harassment when they act to uphold the law. I stand ready to extend my full cooperation in any inquiry that your good office may undertake. So after that alleged compromise, this letter was issued to the Honorable Chairman of the Bar Council, seeking appropriate action against the Lordship Munna Kumar Singh as well as the Respondent 4.
No, but there was a direction from this Bar Council itself to
Again,
report such
lordship,
incident.
what happened on 15th of this month, the Respondent 4 lodged their complaint before the OC of Tinsukia police station, alleging that he is putting pressure and some unknown persons were loitering in the original house of Filobari, and they were demanding the caste certificate from the father of the victim. This was on record. This was lodged on 15th of this month. So, lordship, what cannot be done directly, can we do it, lordship, indirectly, lordship? This petitioner could have come for seeking recourse under lordship 482. But Quashing, lordship, at this stage And Lordship, if Lordship knows that no coercive measure, Honorable Supreme Court in carrying out decision, including Niharika infrastructure, that no coercive measure should
It
not
has to be
passed.
clarified.
Yes, Lordship. But Lordship, he is Lordship Secretary General of the Lordship Bar Association, influential person, Lordship. So he may tamper with the evidence, Lordship. When on specific instruction is that on 15th of this month, the victim has lodged a complaint in regard to this case, Lordship. And that was accepted, Lordship. The some person were loitering, unknown person, within the premises of her house, Lordship. Original house at Filobari, Lordship. So, Lordship, the allegations are very serious, Lordship. If some protection is granted, Lordship, then Lordship, he may temper or hamper, Lordship. And this girl, Lordship, another aspect, Lordship, is that she is a law graduate. And Lordship, at the first instance, she could have been, Lordship, that I am, Lordship, submitting that could have been left with a warning, Lordship. But what is the, and after that, Lordship, a press meet was organized by Tinsukia Bar. This FI, that is their Lordship on record, press meet, Lordship, after the lodging of the first FIR, Lordship. And Lordship will see the press meet. Press meet resolution is there, Lordship.
No, but whether you tendered letter for apology before the,
That is on Sunday, Lordship.
whether you did it or not.
Yes, I did. There's some pressure, Lordship, because I was an intern, Lordship. The whole career was, Lordship, in front of me. But Lordship, on Sunday, Bar Association office is supposed to be closed, Lordship. But why on Sunday, Lordship? There was some fear, Lordship. I will bring everything on record, Lordship, including the Lordship that complaint to the police regarding Lordship, Lordship pressurizing this area. Victim, that threatening, Lordship. Unknown person loitering within the premises of her house, Lordship. She is a law graduate, Lordship. And Lordship may kindly see that press meet was supposed to be, Lordship, conducted. It is in the resolution, Lordship.
That never happened.
But Lordship had that never happened or happened, but Lordship, that was the resolution. But Lordship, at this stage, Lordship, at least till, and Lordship, regarding the maintainability, Lordship, that is also an issue, Lordship. This petitioner could have easily come under section 482 of the CRP, BNSS, Lordship, seeking the protection of anticipatory bail, Lordship. What cannot be done directly can it be done, Lordship, indirectly, Lordship. And Niharika infrastructure, Lordship, is very clear, Lordship. No coercive measure. And Lordship, the 35(3) notice was issued, he did not appear, Lordship. That is also on record. And Lordship, what happened?
35(3) notice was also issued.
Yes, is on record, Lordship. And thereafter, what happened? His brother, Naresh Prasad, he, Lordship, obtained all those, Lordship, that from UP. That documents we dispute, Lordship, whether they are authentic or not. That Lordship, may kindly see at Lordship, page number. And Lordship, if they are alleging that the SC certificate is, Lordship, not genuine, then the Deputy Commissioner should have been made a party, because he is the issuing authority, Lordship. On that premise, Lordship, they are seeking
That is not even an issue.
because they have stated, they have annexed document, Lordship. Because they have stated that the SC certificate hold by the respondent number 4 is not genuine. It is obtained by playing fraud. Who has issued that? Deputy Commissioner, Lordship. So Deputy Commissioner should have been made a party, but they have not been made as a party. Lordship, may kindly see page number, Lordship, 112 for a moment. This family tree obtained by the brother of the Lordship petitioner. These documents we have, Lordship, dispute the veracity of this document, Lordship. When she is granted a SC certificate, so her status of being an SC cannot be, if there is question.
Your, Mr. Chaudhary, your main case
Yes.
for quashing is on the ground that she is not an SC. She does
No,
not
Milord, that
belong.
is one of the ground. That is not my only ground. Milord will kindly see under the scheduled caste Assam order, the community to which the respondent number 4 belongs is not recognized as a scheduled caste in the state of Assam.
That is one ground. And
That way, that way. No, secondly, my lord, kindly see the circumstance. What I'm saying is, my lord, I file an FIR, not in my personal capacity, as a secretary of the Bar Association. It is an admitted position that she is practicing without a license.
That is lordship also under dispute. That is the realm of, within the realm of investigation lordship. That lordship is not holding a mini trial lordship.
Then
That
the all
is-
the then the all the
when
submissions you
can you
made, that is
produce?
also in the
when-
report
when-
investigation.
Mr. Nath, when can you produce?
What other submissions, that is also investigation there.
Heard.
Milord, what I'm saying is, anyway, Milord, eventually we'll argue it is for your lordships to pass an appropriate order in the facts of the case. I am a person, Milord, who has roots in the society. There is no way I'm going anywhere, Milord. Lordship will protect me because I wouldn't have come, because of this petition, Milord, we had to do it. Yesterday, they are not investigating my case properly, the association's case, but very interested in pursuing the other case. So therefore, the role of the investigation officer is also involved. Secondly, my lord, kindly see the attending facts and circumstances. Can't it be said that it is a counter blast as one of the proposition evolved in Milord Bhajanlal's case? Is it not an abuse of the process of law?
It may be or it may not
May
also.
or may not be. Therefore, lordship will take a call at the end of the hearing. Now, my lord, when we come to your lordships, when we make out a prima facie case, normally your lordships protects us. And as your lordship suggested, I'll definitely cooperate, my lord.
But lordship may kindly see the chronology. On 10th of their apology was allegedly given. On 11, 183 BNSS statement was recorded, where she maintained the allegation. That will come with the record, lordship. Thereafter, on 12, this letter was issued to chairman, Bar Council. On 15, the respondent number 4 submitted a petition alleging the lordship pressure put by the lordship.
Heard
That is
Mr.
lordship.
K.
I
N.
agree.
Chaudhary, Learned Senior Counsel, assisted by Mr.
See, Garg.
C. Garg, Learned Counsel for the petitioner. Also heard Mr. D. Nath, Learned Senior Government Advocate, appearing for respondent number 1 and 2. As well as Mr.
And Hassan.
N. Hassan, appearing for respondent. You are also
Respondent
appearing
number-
for 3, Mr. Nath.
By name.
He's by name. That is why I'm not appearing now. For the official respondent 1 and 2, I'm appearing.
Why 3 has been made party?
3 is the IO.
IO, my lord.
Why
Well,
IO
it's
him?
malafide against him. Because he's not investigating our case, he's very busy in investigating the other case.
Respondent number.
That's why, my lord, in 226, I can bring those.
Heard also. Also heard Mr.
The other case is not-
S. Hassan,
And Hassan. lordship.
N. Hassan,
Respondent number 4.
appearing for respondent number 4. This writ petition under Article 226 of the Constitution of India has been filed by the petitioner Shri Bishwajit Prasad, alias Bishwajit Prasad, in praying for quashing of the FIR lodged by respondent number 4 on which date?
9th, my lord.
On 9/8/2025, which led to the registration of Tinsukia PS case number 294/2025. The gist of accusation.
What's its kind permission? Can I take leave?
Yes,
And
yes.
deep reply.
Where is the FIR? Page?
Page 57, that is the impugn. Page 57 is impugn.
Impugn affair.
The FIR sought to be quashed in this case was filed by the respondent number 4 before the officer in charge of Tinsukia Police Station, inter alia alleging that the informant is undergoing internship under Advocate Munna Kumar Singh of Tinsukia Bar Association. It is alleged in the FIR that the present petitioner, who is the Secretary General of Tinsukia Bar Association, has been stalking the informant, that is respondent number 4. It is also alleged that on 8/8/2025 at about 1 p.m. when the informant was standing with other advocates in the premises of the Court of London District and Session Judge Tinsukia, the petitioner clicked her photograph without her consent. And when she objected, the petitioner aggressively questioned the presence of the informant in the court without advocate's license. And he also threatened her that he will see how a girl belonging to scheduled caste community becomes advocate. He also threatened that he would ruin her career. Stop. Learned senior counsel for the petitioner has submitted that the FIR which is sought to be quashed in this case is a counter blast to the FIR lodged by the petitioner in his capacity as Secretary General of Tinsukia Bar Association on, where is that?
8/8.
On 8/8, where is that FIR?
Page 49.
On 8/8/2025. He submits that the respondent number 4 was found practicing in Tinsukia courts without having valid license. And to that effect, in pursuant to the guidelines issued by the Bar Council of where is that Bar
My lord,
Council?
it starts at page 34. 17/12/2021 is the guideline. Page 34, annexure 2. The relevant portion would be at page 36, your lordships.
Guideline issued by the Bar Council of Assam, Nagaland, Mizoram, Arunachal Pradesh and Sikkim to all the secretaries of bar associations to take up the matters regarding those cases where without obtaining advocate's license, the law graduates are found practicing and appearing in the court. It was also stated in the said guideline that necessary action should be taken by filing Ejhar before the police with an intimation to the Bar Council. Stop. And its senior counsel for the petitioner submits that in pursuant to the said resolution, the FIR dated August 2025 was lodged against the present petitioner. He, learned senior counsel for the petitioner, further submits that the after lodging of the FIR, where is that apology? After lodging of the FIR, there has been some development, as on 10th of August 2025, the
Lord, page 66 as well as 68. 66 is the resolution before the bar. 68 is the individual apology of R4.
after lodging of the FIR on 10th of August 2025, emergent executive committee meeting of the Tinsukia Bar Association was held, wherein it was resolved that that the petitioner, that the respondent number 4 and her senior, Mr. Munna Kumar Singh, have tendered unconditional apology, stating that they have committed wrong and brought disrepute to the bar, as well as they do not want to proceed with the Tinsukia PS case number 294/2025. It was resolved that the said apology was accepted, and bar shall not proceed further with Tinsukia PS case number 293/2025. It is also submitted that the respondent number 4 also submitted an unconditional a letter addressed to the president of Tinsukia Bar Association, tendering her an unconditional apology in the matter. It is submitted by learned senior counsel that in the said letter, respondent number 4 has stated that she would not pursue with the FIR which was lodged by her, which led to registration of Tinsukia PS case number 294/2025. Stop. Learned counsel for the petitioner has submitted that as the has also submitted that as the FIR lodged by the respondent number 4 was a counterblast to the FIR lodged by the petitioner in his official capacity against her, and as she has tendered the unconditional apology on 10/8/2025 before the Tinsukia Bar Association, this case is a fit case where FIR lodged by respondent number 4 may be quashed. He also submits that he also prays for interim relief during the pendency of the instant writ petition. Of not taking any coercive steps against the petitioner during the pendency of the writ petition, as it has come to the knowledge of the petitioner that the investigating officer has moved the trial court for issuance of warrant against him in this case. On the other hand, learned senior government advocate, Mr. D. Nath, has submitted that this writ petition is not maintainable in as much as the petitioner has questioned the caste certificate issued to the maintainability. On what ground you are challenging?
Maintainability, I have said that the projection made by the petitioner in paragraph 23 and 24 of the petition is that the petitioner is holding a fake caste certificate, and Lotte here will see whether there is a prima facie case or not. So on the ground of false caste certificate, how the FIR can be questioned? Because the caste certificate is to be examined by the SLSC.
Unless the caste certificate is challenged.
Because the caste certificate is there, it is with the authority, and on the basis of that case is registered. The state level scrutiny committee is the authority who can say the caste certificate is true or not. So the question, the projection made by the petitioner at this stage is not maintainable. That is the main allegation against the FIR.
Caste certificate without challenging the validity of the caste certificate in a separate proceeding
Before the appropriate authority.
before the appropriate authority.
Now, this is the main contention of the petitioner before this court to quash this FIR.
He also submits that before approaching this court by filing this instant writ petition, the petitioner had referred an anticipatory bail before the Court of Learned Additional District Judge Tinsukia, Additional Session Judge Tinsukia, which was rejected by the said court as an application for as the allegations leveled against the petitioner was found by Learned Additional Session Judge to be prima facie true, and accordingly the anticipatory bail application was found to be barred by section 18. Section 18 of the Scheduled Caste and Scheduled Tribes within bracket Prevention of Atrocities Act in 1989. He also submits that though the petitioners, learned counsel for the petitioner has submitted that the petitioner, that the respondent number 4 has tendered unconditional apology on 10/8/2025. However, from the order passed in bail application number 89/2025 by the Learned Additional Session Judge on 28/2025, it appears that in the statement of the respondent number 4 recorded under section 183 of BNSS on 11/8/2025. It was found by the learned session judge that same was same aligned consistently with the allegations made against the petitioner in the FIR. He therefore submits that therefore, what is your
There is
submission?
no case where lordship will entertain a petition for quashing. In fact, 226, even if it is assumed, my lord, it is maintainable. I have the objection as regard maintainability, even if it is assumed, lordship will entertain if it is prima facie, there is no material in the FIR. Then only lordship will entertain the petition. There are materials.
Kalika, that there is no prima facie. No, that as there is prima facie case against the petitioner, this writ petition is not maintainable. Mr. N. Hassan, learned counsel for the petitioner, learned counsel for respondent number 4, who has appeared in this case by filing his wakalatnama, has submitted that once the prayer of anticipatory bail by the petitioner is rejected by this court, by the court of learned additional session judge Tinsukia, on the ground that same is not maintainable in view of section 18 of the Scheduled Caste and Scheduled Tribe within bracket Prevention of Atrocities Act 1989. The same relief cannot be sought for in an indirect way by filing this writ petition. He also submits that though an apology letter was filed by the respondent number 4 before the Bar Association of Tinsukia, it was done under pressure as the respondent number 4 on the very next date in her statement recorded under section 183 had reiterated the allegations which she leveled against the petitioner in the FIR lodged by her. He also submits that the petitioner also did not honor the resolution adopted by Bar Association of Tinsukia on 10/8/2025, as on 12/8/2025, the petitioner lodged a formal complaint to the Bar Council of Assam, Nagaland, Mizoram, and Arunachal Pradesh regarding alleging impersonation of advocates, impersonation as advocate by by respondent number 4, and lodging of retaliatory false FIR by her. I have considered the submissions made by learned counsel for
15th of this month, the respondent for written to the lordship was the OC regarding lordship threatening of on the part of petitioner.
That's not on record.
There is lordship, I have specific instruction.
Where is that?
There I cannot put a belief on that, but I have specific instructions.
Okay, when he threatened,
On 15th, Lordship, the complaint was lodged. On 14th, some unknown persons were loitering near the house of the Lordship, Respondent 4, original house, Lordship, in Filobari. And Lordship, they were seeking, asking the father of the Lordship, Respondent 4, to produce certificate, Lordship.
If I may,
Specifically.
if I may, your lordships, that complaint would be a separate complaint.
No, Lordship, in
Will
this
not
case
have any
only.
bearing to do with this.
In this case only.
Learned Counsel for the respondent number 4 has also submitted that after lodging of the FIR by the petition, by her against the present petitioner, she is facing threatening no, some unknown persons were found loitering against,
And also she specifically named that those persons who are
loitering in the,
those persons are
in and around the house of the present petitioner.
those persons are being associated with the brother of the petitioner, Noise Prasad, specifically.
And she had lodged an FIR before the officer in charge of Tinsukia police station.
Not a fact. The particular act.
She has lodged a complaint before the police alleging that you have named the petitioner,
So, those persons are connected to Lordship, brother of the petitioner, Noise Prasad.
that
He is also an advocate.
that the persons found loitering against her around her house were related to the brother of the present petitioner, and she is feeling insecure due to that fact. Stop, I have considered
Then
the
protection was sought.
protection was given
That,
and she sought for police protection. I have considered the submissions made by learned counsel for both sides. Let the notice be issued in this case. Since Mr. D. Nath has appeared on behalf of respondent number 1 and 2, no formal notice need to be issued against the said respondents. As Mr. N. Hassan has appeared for respondent number 4, he also need not to be, notice also need not to be issued formally against the said respondent. However, the petitioner is directed to furnish requisite copies of the writ petition along with the annexures to the said respondent. The petitioner shall take steps for issuance of notice upon the respondent number 3 within 7 days from the date of respondent number 3 by registered post with ID as well as by usual mode within 7 days from the date of this order. When can you produce the case diary?
Immediately on Monday or Tuesday, my lord, I can produce the 183 statement is there, lordship wants to produce, that I can produce. The case diary I can produce on Monday. Or
No, be sure. You
Lordship-
take time.
Lordship may give us Tuesday, my lord. But prima facie, I just want to place before your lordship, the prima facie materials are there. On Tuesday, my lord, I'll place.
On Tuesday.
Tuesday, I'll place.
May then have it on Thursday.
Thursday.
May have it on Thursday because the learned senior counsel.
Malad, my colleague is there, learned PB. By tomorrow, we can place it. We'll place it tomorrow.
May have it on Monday.
No, if they are able to produce it tomorrow, then
Tomorrow. We'll
I'm not
produce it.
granting any interim
By tomorrow, we'll produce. We'll produce.
if they produce tomorrow.
Well, it's subject to them.
Okay. Returnable on returnable after 3 weeks. However, the learned senior government advocate is requested to produce the, no, however, as learned senior government advocate has submitted that he will be able to produce the case diary of Tinsukia PS case number
294/25.
294/2020.
Let them produce both cases, Malaj. 293 as well, 294.
294, no, that is not required. That I will accept your submissions. 293/2025.
294. 294 is impugned.
Okay, 294/2025.
Yes.
Tomorrow itself. Therefore, list this matter again tomorrow.
Tomorrow.
Tomorrow again.
Tomorrow. Latima, kindly accommodate us till at 2. Tomorrow at
Tomorrow at 2 p.m.
Tomorrow.
2 p.m.
Till then, no coercive steps, till this matter is still before the court. They can produce.
We are producing it tomorrow. Lordship is considering tomorrow. Tomorrow, Lordship, after perusal of the diary, Lordship will consider.
No, they have prayed for issuance of warrant.
That's correct.
Whether warrant has been issued,
No, not yet.
yes or no? So till tomorrow,
Lordship, let us produce the case diary. Lordship is considering tomorrow. It was the FIR was lodged on 9/8. Today is 28.
tomorrow, no interim till tomorrow.
Well, at least interim may be considered till tomorrow because there is an application which is filed. Let them produce they've made a submission, they'll produce the.
Lordship already the order is.
It may be considered tomorrow, your lordships. If your lordships feel that your lordships are not inclined to give us any interim, that may be considered tomorrow.
But it will complicate. We are producing the case diary tomorrow. Lordship is.
No, how it will complicate?
I am calling the case diary today. But it is coming.
So, Miloj,
The petitioner shall not be arrested till.
May I just interrupt? Lordship is facing the matter tomorrow at 10:30 or 2 o'clock. And for that purpose, we are calling the case diary by special messenger. Interim order may be considered tomorrow. Otherwise, there is no point of hurrying up the whole thing.
No, if there is no ground for.
Otherwise, without case diary, Lordship may grant the interim bail. That discretion is with the honorable court. But if Lordship is calling the case diary, otherwise the notice has been issued for 3 weeks, if I'm not wrong.
Yes, sir. 3.
So let the interim order be considered tomorrow after perusing the case diary.
No.
That is discretion, but why we are saying that we'll produce the case diary? Because Lordship is considering an interim period tomorrow. If Lordship is granting
No,
the interim, then
till tomorrow, if there is no protection.
he is absconding from 9th. The FIR was of 9th. Today is 28. So for last 20 days, he was absconding. One more night will not give the heaven will not fall down. Let him abscond for one more day.
Precisely what I am also saying. If they are producing the diary tomorrow, let my lord.
Yes.
Yes, it will be considered tomorrow.
My lord, protect me for a day.
Till.
Then in that case, we will not produce the case diary tomorrow. Let it be in the regular course. There is no point of otherwise Lordship grants time for 1 week or 2 weeks for bringing the case diary, granting the interim prayer. But if Lordship is granting the interim prayer today itself, then there is no point of bringing a special.
Why there is no point? When this court is saying that it intends to peruse the case diary tomorrow, and tomorrow it may be vacated also if after perusal of the case diary, if 183 statement
I leave it to your
reflect
Then the
otherwise.
discretion, this is our submission only.
Yes, what is the last line? Arrested in connection with the Tinsukia PS case number 293. What is the number?
294.
290
294.
to 294 of 25 till tomorrow. List accordingly.
A pleasure.
This is a matter relating to CGST Act Law 2017. The petitioner before your lordship is a coal merchant operating from Beltola area. He was subjected to search and seizure. If lordship is pleased to come to page 17.
This is a
Search and seizure issue.
you
And
are
subsequently, I was
already
issued-
arrested. You are behind the bars.
I am behind the bar from the 28th. I was given a summon, I appeared. They made me detain for more than 24 hours. I am not on that. Then thereafter, they arrested me. Identical persons are all released by the lower court on the very first day. My co-accused or whoever. So absolutely without determination of the assessment, they have come to some conclusions, which in my humble submission is not proper and their own. Let me go to this. Let me first produce their principle or their SOP, how a person can be arrested and bail can be granted in respect of offenses under the CGST Act 2017, page 30.
Yes.
So this was issued by the investigation wing of GST, subject guidelines for arrest and bail in relation to offenses punishable under the CGST Act 2017. The Honorable Supreme Court of India in its judgment dated 16th August 2021 in criminal appeal number so-and-so arising out of SLP so-and-so has observed as follows. We may note that personal liberty is an important aspect of our constitutional mandate. The occasion to arrest and accuse during investigation arises when custodial investigation becomes necessary or it is a heinous crime or where there is possibility of influencing the witnesses or accused may abscond. Merely because an arrest can be made because it is lawful does not mandate that arrest can be made. A distinction must be made between the existence of power to arrest and justification for exercise of it. If an arrest is made routine, it can cause incalculable harm to the reputation and self-esteem of a person. Now, this is the line I am harping upon. If the investigating officer has no reasons to believe that the accused will abscond or disobey summon and has in fact throughout cooperated with the investigation, we fail to appreciate why there should be a compulsion on the officer to arrest the accused. So if these two conditions are not there, that under the CGST law, that the accused, there is a possibility that he will abscond or he will dishonor the summon. In those situations, the Honorable Supreme Court said that the investigating officer has the right to exercise his power to arrest by arresting the concerned accused person. So this is the situation. In my case, Lordship will kindly come to page 17. This is the form GST INS 02, order of seizure. Whereas search under subsection 2 of section 67 was conducted by me on 19/8/2025 from 8:45 hours to 11:30 hours under authorization of searching under so-and-so dated 18/8 in the following premises. Residential premise of Gaurav Agarwal, so-and-so at Guwahati. In presence of the witnesses Dimple Deka and Subham. And on scrutiny of books of accounts. So I have produced everything. Registrars, documents, papers, and goods found during the search. I have reasons to believe that certain goods liable to confiscation or documents or books or things useful for or relevant to proceedings under this act are secreted in place mentioned above. Therefore, in exercise of the power conferred by me under subsection 2 of section 67, I hereby seize the following goods, that is, details of the goods seized nil, details of books, documents, things, annexure 8, which Lordship will find at page 18, next page. So they have seized one mobile phone and one Lenovo laptop. I have produced everything before them. So this was seized. Thereafter, that Panchanama was prepared, page 19. Here, very important thing, this Dimple Deka and Subham, they were the witnesses, and Lordship will kindly come to page 20. I am reading the top line. On reaching the above mentioned residential premises, the punchers along with the officers knocked the
Where
door.
are you reading? First
Page
line.
20, the
Okay,
first line. On reaching the above mentioned residential premises, the punchers along with the officers knocked the door and was opened by one person who identified himself as Gaurav Agarwal. Thereafter, the officers in presence of the punchers, introduced themselves by showing their identity cards as officers of DGZI, Guwahati Zonal Unit, and shown authorization for search dated so-and-so, issued by the Joint Director, Guwahati Zonal Unit, and explained the purpose of their visit. In token of having seen the same, Sri Gaurav Agarwal puts his dated signature on the body of the authorization of search and allowed the search. So there was no objection from my side. Before commencement of the search, the officers of the DGZI, Guwahati Unit, offered themselves to Gaurav Agarwal for personal search, which was politely declined by him. The search is started at 8:45 of so-and-so. So they wanted me to search them also. I declined and I offered everything. So this was the cordial way I have conducted myself with the investigating officer. Thereafter, the wife's everything is detailed in the next paragraph. During the course, third paragraph I am reading, during the course of search, a mobile band number so-and-so and laptop so-and-so, which belongs to Gaurav, were found and same is seized under GST on reasonable belief that the same are relevant for the further investigation. And for the seizure of mobile phone and so-and-so, a digital device collection form is also prepared. I have also given them the passwords, etc. So they could open everything. So this is how I have conducted myself with the investigation process. Next page, that is a summon they have issued under section 70 of the CGST Act 2017. I, Alokesh Day, am making inquiry in connection with GST investigation with fake tax invoices of coal, coke, etc. without actual supply of goods under CGST Act, and wherever I consider your attendance is necessary to depose verbally and in writing. So they want me to give my statements only. There is no request for any documents, no request for any accounts, no request for any other materials. So they wanted me to depose and I attended. So I was called at 2 p.m. So I attended, and next day at 3:50 I was arrested. I was made to sit in the office for the whole day, and next page Lordship will find that. Second paragraph, he has been arrested in connection with supply of goods without issuance of proper tax invoices in violation of provision of CGST. So there is no case of fake documents now. When my wife was informed by the investigating officer after my arrest, this was addressed to Chandana Agarwal, who is my wife. So they have informed my wife that he has been arrested in connection with supply of goods services without issuance of proper tax invoice in violation of the provisions of section 132. Then Lordship will kindly come to next page, page 24, authorization to arrest. So reasons to believe. My humble submission on this is that they have quantified a particular amount.
Yes.
Investigation has revealed that Gaurav Agarwal is so-and-so, is a part of a syndicate which provides fake invoices and e-way bills to certain suppliers of coal. These fake invoices and e-way bills are generated in the name of following 9 unknown, unrelated business entities. Evidences, including the voluntary statements, WhatsApp chats, have revealed the above said fake invoices and e-way bills has been used in the syndicate to supply coal without payment of GST, as this supply has not been declared in the GST returns, leading to evasion of GST of 28 crores. during the period of so and so. So they have quantified this amount of 28 crores on the ground that there is evasion of tax. On the earlier occasion, they said that the document from some WhatsApp chat, they have found out that some supplies were done. Now they have quantified here, but to get the quantified amount, an assessment has to be done. That is why these reasons to believe an authorization arrest is totally non-tenable in the eye of law. I will furnish a judgment on this. To come to this figure that 28 crores 95 lakhs 66,855, a detailed process has to be done, just like our income tax assessment. So without that exercise, they came to my place. I produced all the documents. They did not look at into it. They searched and seized two equipments. One is a mobile phone. The other one is a laptop. Next day, they call me for giving my statement to depose verbally and in writing. They did not ask that produce some documents. If Lordship is pleased to come to page 22 once more, how the summon was issued.
Okay, CGST Act provides for penal provisions.
Absolutely, but that has to be done after.
What is the penalty?
Penalty will be if ultimately in the assessment it has come to the conclusion that I have evaded tax. So it can be 3 months to 5 years punishment.
3 months to 5 years.
Yes. So, but for that, a detailed exercise has to be done. So now, after that, I was produced before the court. So the Lordship will kindly come to page 29. They wanted custody. So my custody was over on 4th day, 24/8/2025. Present so and so. Accused Gaurav Agarwal is produced before me after completion of 4 days of departmental/police custody. So here it is departmental custody. Then last paragraph, last but third paragraph, considering the nature of offense and the investigation is still at the nascent state, I deem it fit to allow the prayer for sending the accused to judicial custody. So the departmental custody is also over. Then the superintendent of central jail is directed to ensure food and medical treatment so that he stays in judicial custody as per section 56. So the case is very plain and simple. Lot of people do not pay tax as per their expenditures or whatever. But for that, a assessment notice is issued. They do a detailed exercise. I get the opportunity to produce documents. Without anything of this nature, they have come and concluded that there is a evasion of 20.
What is the penal provision?
Penal 132. 132(1).
And how the charge sheet is filed, whether it is form of complaint? Complaint.
Investigation is completed.
So till now, complaint is not there. Without a complaint, I am behind the bar for last 9 days.
What is the stage of investigation?
The initial stage and many materials have been collected during this period. I'll produce on Tuesday or Wednesday, Lordship. Everything I'll produce. And
You maintain a case diary?
no, we are maintaining the file.
Records.
Yeah, record.
Let them produce the record.
So my humble submission here is that I should not be there for a single moment. This whole exercise of arresting me is totally illegal from the very beginning. I also get a notice from income tax or service tax earlier. Does this mean that I have to be arrested immediately? Every person, if
Where is the reason?
Page 24.
there's a whole conflict in the arrest memo is there. Arrest memo says something else. The reason says the opposite.
Don't say that I will text.
And their own principle says that they can arrest only when
You
there
have.
is a chance of my
Yes,
absconding.
Mr. K.R. Your own department has issued guidelines
Yes, Lord.
for arrest.
Yes.
how you would justify?
Because Lordship under section 69, reason to believe is to be prepared before that. Lordship, that please go through that, and I produce the record on Wednesday or Tuesday. Lordship may produce the record. If the arrest is illegal, immediately Lordship can pass an. And Lordship, and thereafter on 28th of April, Radhika Agarwal has passed, Honorable Supreme Court has passed judgment in Radhika Agarwal. This will clarify everything. Assessment is not necessary if the department comes to a conclusion that the custody intervention is
No,
necessary.
but you have to give reasons.
Yes, it
that-
is there, Lordship. Lordship, please to see page 24.
No, 24 only says the accusation against him.
Lordship, please to see next page, page 25. Investigation is still at initial stage. He has not divulged all the details about this syndicate and certain crucial facts, information related to GST evasion. Thus, his procedural integration, which is elicitation oriented, is absolutely necessary in this case. There is no need to cover other associated persons, namely brokers, wholesale suppliers, and his other associates involved in the GST evasion. At this stage, the investigation, there is possibility that he may influence witnesses, temper the evidence, and settle the ongoing investigation. Everything is there. And furthermore, Lordship knows that GST is collected here. State has also 50% share in this case. And Lordship, the petitioner has filed a application on report 483. That is also to be taken into consideration. And Lordship, in the bail application, they have made a statement. Lordship, please to see.
Yes. Which statement?
Lordship, I'm pleasing.
No, the records would be necessary
Yes, Lordship.
because your plea is that he has been arrested in violation of the guidelines issued by the department.
Yes.
Now, they have given some reasons. Now, whether that reasons are justified or not.
Let it be taken up tomorrow. Lordship, let them produce the records.
More Lordship, I am going to Itanagar bench. Lordship, it's on Tuesday.
They have other counsels.
No,
For
Lordship.
my
Lordship.
liberty, now I am reading a judgment.
Lordship,
Perusal of
I have
the,
serious
now,
objection in this case, appearing by my learned friend, because he is the Advocate General of State of Assam. And here, Lordship, the text is divided between the state and the central 50-50. So this is
now
another.
it has been personal.
No. This
Who are the
is-
opposite party?
This
Yes.
is not a
Okay.
personal.
I am appearing in against CBI, against NI, all.
Let him produce the records
Let it come
on-
tomorrow,
Tuesday, Lordship.
on Tuesday.
on Monday, Lordship.
Mr. D. Soika, learned senior advocate, assisted by Ms. N.
Let him put it on a record that my appearing in this case, he
Yes,
has
Lord.
objection.
Yes,
Let him
Lordship.
put,
That may be put.
let him put it on record.
Yes, Lord.
Ms. M. L. Gop, learned counsel for the petitioner. Also,
Basic
Mr.
fundamentals should be known by person.
N.C. Kakar, learned
Standing
standing,
of the DGGA.
standing counsel,
DGGA.
DGGA,
I.
DGGI. It stands for Director General of GST Intelligence. Okay. This application under section 483 of BNSS has been filed by the petitioner, namely Shri Gaurav Agarwal, who has been detained behind the bars since 2025 in connection with DGCI, in connection with case number DGCI/INV case number 118/2025 relating to file number DGCI/INV/118/2025 GRC dash Office of ADG DGCI ZU Guwahati Part 3. Learned counsel for the petitioner has submitted that the petitioner, in spite of rendering all cooperation to the investigating officer, investigating official of the DGCI, has been arrested in this case in violation of the guidelines issued by the department for arrest on 17 August 2022. He submits that the petitioner, before 1 day before his arrest, had appeared before the DGCI officials in pursuant to the summons received by him, and he has rendered full cooperation in the investigation. Learned Senior Counsel submits that there was no occasion or any compulsion on the part of the officer who arrested the petitioner to arrest him had he followed the guidelines for arrest issued by the GST investigation wing on 17 August 2022. On the other hand, learned Standing Counsel DGCI, Standing Counsel DGGI has submitted that sufficient materials are found against the petitioner during investigation, and the investigation is at a very initial stage. He also submits that before effecting the arrest of the petitioner, reasons in writing were mentioned in the authorization letter to authorization to arrest, justifying as to why the petitioner had to be arrested. Stop. He further submits that during preliminary investigation, it has been found that the petitioner has been involved in evasion of GST to the tune of rupees 28.95 crores. Stop. In response to the said submission, learned Senior Counsel for the petitioner submits that the quantification of the tax evasion has been done without any assessment made to that effect, and same may not be relied upon. So I have considered the submissions made by learned counsel for both sides. For considering the submissions made by them, this court feels that perusal of the relevant case record relating to the investigation of this case would be necessary before the application for bail may be considered. Hence, the learned Standing Counsel DGGI, Mr. A.C. Cal, is requested to produce the relevant records on Tuesday. That is
It will be on Monday, Lordship.
Monday. Will you be able to produce?
Fix on Monday.
Okay, on Monday. That is on 1st of September.
The only thing regarding my appearance, I have just found out Director General of GGST is an apex intelligence organization functioning under the Central Board of Direct Taxes and Customs, Department of Revenue, and Ministry of Finance, Government of India.
Okay, I have not brought that.
Then
in.
that is why, and the respondents all here are because certain kind of loose objections are made, which is not appreciated.
Lordship, here.
We are not deciding it. You can take this
The
plea again on
fund
Monday.
fund is always distributed into various
Yes.
factors.
That is important to be noted.
Monday,
No.
on Monday.
I'll produce to you.
If they do not want my appearance, that is a fine, but not at the stake of saying that I cannot appear.
No, Lordship,
If
this
he
is the
is,
fact.
if he is little bit worried that
No,
I am
I'm not
appearing,
worried. I'm not
then-
worried about any
then-
appearance of anybody. My learned senior can prepare, but I'm just pointing out what is the system of distributing the tax between the state and center.
that all funds are distributed. Income tax
Now,
also. I
now,
appear against
now,
income tax also.
now, reserve something for Monday also.
Income tax is different, Lordship, GST is different. The scheme of GST.
Income
different.
tax is also devolved to all the states. All finance commission amount is devolved to all the stakeholders, including state government.
That the income tax deposit in the.
Not-
consolidated
Deeply
fund.
obliged.
Not today, on Monday. Oh,
Can you peruse the order dated, my lord?
we'll.
It is part heard before the honorable justice file of Panganga. Kindly peruse the order.
It was part heard,
Yes, sir. 12/8/2000.
heard Mr. NNB Chaudhary.
Actually, he's already heard the matter, my lord. He want to show some document, my lord. Please document.
Heard Mr. NNB Chaudhary, London counsel for the petitioner, also heard Ms. M. Deka, London additional public prosecutor. And sorry, Learned counsel for NCB. Learned counsel for the petitioner has submitted that this matter has been kept part heard, has already been heard in part by a coordinate bench of this court, within bracket Honorable Mr. Justice Pranjal Das. Stop. Considering the submissions made by learned counsel for the petitioner, the registry is directed to list this matter before appropriate bench.
My duty is so much.
Yes. You can.
Lordship, with your permission, I apologize. Your Lordship should pass the order in item 13. Lordship, Mr. Chaudhary is actually not available tomorrow. That's why, Your Lordship, I'm making this request that if Your Lordship may have it on Monday. We've
No,
informed the other side as well, Your Lordship.
Not informed, Malat, we have been instructed, Malat, by senior governor, he is an urgent matter in code number 3. But we have already called for a CD, talk with the OC Malat. They are bringing the CD by tomorrow morning.
Well, the difficulty is that after Your Lordship's passed the order, we were informed by the learned senior's office that he's not available.
no, tomorrow you make, I'll only go, you have already made your submissions.
That's correct, Your Lordship.
So I will only go through the case diary. 183 statement. You make your submission tomorrow.
My lords may then allow us to mention it tomorrow. And the only difficulty is, my lords, that the learned senior is leading us and
Okay,
be
I'll
difficult.
consider it tomorrow because already case diary has been
Like,
called for.
Signal has been sent and telephonically instructed the OC also, Malat, that they are bringing the CD, Malat, by
Yes,
special messenger.
let us see tomorrow what happens. You appear tomorrow.
obliged, Your Lordship.
May I please? Sorry, Your Lordship, I am mentioning on item number 14, in my petition. That the CD was called for, CD is not available. It's another date.
40
1/4.
141.
14.
Admission material.
Heard Mr.
Yes.
S. Islam, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor, who submits that the case diary which was called for has not yet arrived. Hence, prays for some more time for producing the case diary. Prayer is allowed. When? Let this matter be listed after 2 weeks. You are on interim.
No, that's not.
When?
16?
On
10th, my lord.
on 10th of
September.
Let this matter be listed on 10th of September.
Obliged.
16.
May I please, your lordship.
Yes.
Your lordship, the petitioner was arrested on 17/6/2023. This is NDPS case, lordship. And lordship, I am seeking bail on the ground of prolonged incarceration, lordship, since
What-
last 2 years, 2 months and 14 days. The petitioner was arrested on 17/6/2023.
What is the contraband?
Contraband, lordship, 1,900 yoga tablet.
What is the weight? Weight is given.
Yes, lordship.
182.88 grams. How many witnesses are there?
9, lordship.
How many have been examined?
3.
Yes, Mr. Sharma.
And another thing is that
Yes, another thing.
the petitioner was arrested, lordship, on the strength of one NBWA, lordship. In the present case, lordship, only one petition of one person is there. Against the present petitioner, search sheet was submitted. He was shown as absconder. On the basis of the NBWA, he was arrested on 17/6/2023. And since then, lordship, he is in custody as of now, 2 years, 2 months and 14 days. That is my question.
Otherwise, lordship, commercial quantity and seizure was made from the house of the
House of the
petitioner. He absconded, lordship. And he remained absconding, lordship, and then on the NBWA as well as proclamation was issued. And he was arrested thereafter, lordship. And charges were framed on 11/10/23, lordship. 22C. And lordship, the next date is fixed on 9/9 for evidence. Otherwise, lordship, the prolonged.
Where do you belong?
The same locality, lordship.
My submission will be, lordship, some Indian condition will be given, lordship.
Yes.
because we-
Where do you stay?
Police station, Badarpur, district Shivani. Local resident.
Heard Mr. M. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, Mr. B. Sharma, learned additional public prosecutor. This application under section 183 of BNSS 2023 has been filed by the petitioner, namely Abdul Subhan, who has been detained behind the bars since 17/6/2023, within bracket for more than 2 years, 2 months, bracket close, in connection with special NDPS case number 4/2022. The gist of accusation. This is your first bail application.
Yes, sir.
The gist of accusation in this case is that, where is the FIR?
FIR, lordship, is at page number 17.
That on
19, the main part is at 19, lordship. 19.
date of FIR is
Date of FIR is 6/1/2022.
that on 6/1/2022. One Sandeep Rawat had lodged an FIR before the officer in charge of Badarpur Police Station, inter alia, alleging that on receipt of an information through reliable sources, the house of the present petitioner was searched and during search 1900 numbers of Yaba tablet weighing about 182 point. What is the weight?
That is lordship. Weight is lordship 172.13 grams without net weight loss.
172.13 grams were recovered therefrom. Learned counsel for the petitioner has submitted that the petitioner was arrested on the strength of non-bailable warrant of arrest issued against him, as he was shown as absconder in the charge sheet. He submits that since the date of his arrest, the petitioner has been languishing behind the bars. And he further submits that though there are 9 listed prosecution witnesses in the charge sheet, however, till date, only 3 have been examined. And at this phase, it is unlikely that the trial would culminate soon. Learned counsel for the petitioner has which cases you are relying?
Yes, submit.
What is the name? Court paragraph number 8. 8 from bail application number 3881/2023. Dated 22/1/2024. Court para 9. The other hand, learned counsel for the learned additional public prosecutor, Mr. B. Sharma, has opposed the grant of bail to the petitioner on the ground that the seized contraband was recovered from the premises of the petitioner, and as it is of commercial quantity, the embargo of section 37 of the NDPS Act would be applicable to this case. I have considered the submissions made by learned counsel for both sides and have gone through the records of this case, including the scanned copy of the trial court records, which was requisitioned in connection with this case. It appears from record that since the date of arrest, that is 17/6/2023, the petitioner has been detained behind the bars, and though the charges were framed on 11/10/2023, however, till date, only 3 prosecution witnesses out of total 9 listed prosecution witnesses have been examined. And therefore, there is an unlikelihood of early culmination of the trial. Court para 17, 18, 19, 20, 21, 22, 23, 24, 25, 24 and 25 tenure change করে দিল। In view of above, the petitioner is allowed to go on bail of rupees 50,000 with 2 sureties of like amount, within bracket, one of whom 2 sureties of like amount, subject to the satisfaction of the trial court with following conditions, same conditions. This government, no, he resides in
Resident.
local resident.
Let there be two share.
This bail application is accordingly disposed of.
Item 17.
Highly applied.
My please, Lord. This is the searched matter, your lordships. In this case, your lordship, 9 witness is there. And as per record, 7 witness has already been examined.
Also, again, Lordship, already 313 statement has been recorded.
Recorded.
Yes, and Lordship, the next date was fixed on 14/8 for argument, Lordship. The same type of commission is making repeatedly. On last occasion also, Lordship, I had addressed the court on this, Lordship. I had even asked him to go through the records.
Yes.
What happened on 14/8?
I had seen your lordship, 313 statement was
Then
recorded.
how can you say, Lordship, that
So,
witnesses
Lordship,
are not over?
today I-
If 313 has been recorded.
Today, I have uploaded the status report, that is production of witness, your lordships. So initially, I was filed this case. At that time, 4 witnesses already examined at that time. But as per office note, you see, there are 2 times or 3 times call for the case record, and in the meantime, the learned special judge already examined other witnesses.
Now your 313 statements have been recorded.
Yes.
On 1/8/25. And Lordship, the next date was fixed on 14/8/25 for argument. That is why, Lordship, on the last occasion,
What happened on 14/8?
yes, Lordship, that is why the honorable court asked for a status report which has not been received, Lordship.
What happened on
The
14/8?
last occasion, I have now filed one additional affidavit and it's saying that
That is not
41
actual,
notice has not been complied at that time when
On the
the
last
accused
occasion,
person was arrested.
No, what is your answer? Whether what happened on 14/8? Because you are facing trial, you must know what happened on that day.
Yes.
What happened on that day? 14/8.
14/8/2025.
You don't know.
that is on the last occasion, Lordship, the honorable court asked for a up-to-date record, Lordship, up-to-date status report. That has not been received,
Because
Lordship.
14/8, 28/8.
So we
If
can-
argument was heard, then by this time, judgment might have been delivered. If judgment is delivered, your bail application becomes
But
unfructuous.
today in the morning time, I'm uploaded on status report that reflected that not argument status.
So. Sometime it is not updated.
Now, today is itself fixed, your lordship, 28/8/2025,
For what?
production of witness.
No production of it.
Today itself is 28/2025, today is fixed.
Production of accused.
It was today, sir.
We are calling for a status report.
That was already called for, Lordship. It has not been received as per the office note.
And
Oh,
your
yes,
lordship,
it was called for. Indeed.
It has not been received as per the office note dated, Lordship, 26/8/25.
earlier occasion, your lordships, 2 times you were called for, but in the meantime,
Which is the court?
special just Kamrup Metro.
Roberto Kobo telephone করে report on. Heard Mr. S. Islam, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Ms. M. K. Brown appearing for respondent number. Learned amicus curiae appearing for respondent number 2. It appears that on last occasion, that is 21/8, on last date, that is 21/8/2025, this court has called and up-to-date status report of the trial pending before the trial court. However, from the office note dated 26/8/2025, it appears that the up-to-date status report has not yet been received. Let a reminder be issued. The AOJ of which section? No. Let a reminder be issued. Stop. Let this case be listed again on DVD. 14.
Long exported maybe when authorized, the learned special was completed.
The last occasion also that was paid, but I in fact like to address the court also that it takes some time to get the status report. They
Let it be on 14. 15. 15. 15/8. We will bring,
10 or 11.
no, it is not possible. Trial court recorders. Yes,
The charge sheeted case, lordship, already charge sheeted. And it's
Foxo.
Yeah, Foxo lordship. Respondent appeared lordship. And also has filed an affidavit.
objection.
I don't think so. It's an objection.
You have no objection.
Ah. There is no objection if a bail is granted. lordship.
Why you are not objecting?
My daughter insists on being with the accused.
Okay. Yes, Mr. Sharma.
Only
What is the stage?
it is also evidence, but witness has not yet been examined. Charges were framed on lordship 2/6/25. And lordship, the date of birth of the victim girl is
What is the date of your arrest? Since when you are behind the bar?
Since 19-2 lordship. 19-2. I have stated in paragraph 5 lordship.
Yes, Mr. Sharma, anything?
lordship, only thing lordship, the date of birth of the victim girl is 2/11/2010. So she was around 14 years.
15.
2/11/2010, 14 years at the time of occurrence. And her lordship, otherwise her 164, 183 statement that has been recorded lordship is on the similar lines of having some sort of relationship. I flag mark, the only impediment is lordship the POCSO. So her consent doesn't matter, and lordship, charges were framed on 2/6/25 under 87, 65(1) and 6 of POCSO. 2/6/25.
Heard Ms. D. Ghosh, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, as well as Mr. R. Day, S. Day, learned counsel appearing for respondent number 2. Respondent number 2 is the mother of the victim. This application under section 483 of BNSS has been filed by the petitioner Rohan Day alias Rahul, who has been detained behind the bars since 19/2/2025. How many days you are?
Till date.
Till date. 19/2/2025. In connection with special case number 83/2025 under section 96 of BNS, read with section 6 of the POCSO Act. Learned counsel for the petitioner has submitted that the what is your submission? What
Lordship, they have a relationship. And he was actually that day, she was not with him. He had dropped her to her friend's place. She was scared. Reason is that her uncles had seen both of them together in bike because he used to drop her in her workplace.
where is
She
the
was-
FIR?
FIR is at page Lordship. 15 Lordship. Initially missing report was lodged. FIR 27 is the vernacular Lordship.
The gist of accusation in this case is that on
191. Lordship, 191 days.
on 18/2/2025, the mother of the victim girl, within bracket respondent number 2, bracket close, had lodged a missing complaint before the officer in charge of Pragjyotishpur police station, inter alia, alleging that on 15/2/2025, her daughter, within bracket victim, went out from her home and did not return back. She could not be traced out in spite of vigorous search made out for her. Stop. Learned counsel for the petitioner has submitted that the petitioner was having a relationship with the victim girl, and on the date of alleged offense, he had dropped the victim girl where?
He was about to drop her in her home. He only insisted that you should return home, your parents will be worried. So in paragraph 7, I have
Insisted her to go back to her home, and the victim girl, out of fear, decided to stay at Panikhaiti at her friend's place. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 191 days, and he is ready to face trial. She submits that considering the period of detention undergone by the petitioner and his willingness to face trial, he may be allowed to go on bail. On the other hand, learned additional public prosecutor has submitted that though in her statement recorded under section 183 of BNSS, the victim girl has admitted that she was having an affair. She was in an affair with the petitioner. However, at the time of alleged offense, the victim was minor. Stop. And he also submits that though the charges have been framed on 2/6/2025, evidence, no prosecution witness has been examined till date. Stop. On the other hand, Mr. M. Day, S. Day, learned counsel for the respondent number 2, has filed an additional affidavit, stating therein that respondent number 2 does not have any objection if the petitioner is released on bail, as the respondent number 2 also came to know about the relationship of her daughter with the petitioner stuff. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of special case number 83/2023. So, since the respondent number 2, who is the informant of this case and mother of the victim girl, does not have any objection to grant of bail of the petitioner, and also considering the period of detention undergone by the petitioner, this court is of considered opinion that if the petitioner cooperates in trial, his custodial detention may not be necessary for fair completion of the trial of special case number 83/2023. In view of above, the above named petitioner is allowed to go on bail of ₹30,000 with one surety of like amount, subject to the satisfaction of learned. Which court?
For Kamrup Metro, for special court.
Learned special judge. Kamrup, special judge within bracket POXO, Kamrup Metro, with following conditions, number 1 and number 2. This bail trial condition, this bail application is accordingly disposed of.
Did give like.
I have 45 from supplementary.
On the last location, Malad, it came up on 26th, Malad. After going to the record, Malad, the 48 notice is not available.
Lordship, this matter was Padhat, Lordship. Lordship, I'm praying for adjournment. Today, my senior will not be able to appear, Lordship.
This was parted by whom? This court.
Yes.
Not shown as parted.
Not
Last days,
appeared on last day, Lordship. My senior appeared, Lordship.
on 26th, Malad, your lordship passed that order.
Yes, where is that 48?
48 notice from the
You
record.
you said that investigating.
What is?
Yeah, it is there. Are you praying for adjournment? On what ground?
Five
When he will be there?
on Monday, Lordship.
48 is there, notice is there, Malad.
This is 47.
14.
Okay, we'll take it up on Monday. Let him come.
47.
Give a copy of. If you have 48, section 48 notice, give a copy of the same to the petitioner. Heard Mr. N.J. Dr. Learned counsel for the petitioner. Also, Ms. M. Deka, Learned counsel for NCB, who submits that Learned standing counsel NCB, Mr. S.C. Kayal, due to some personal difficulty, could not appear before this court today. And on that ground, she seeks a short adjournment. The prayer is allowed. Let this matter be listed on 1/9.
May I make a small submission, my lord? My lord, in NCB and these cases, my lord, after filing the charge sheet, the documents are not there on the record, in the court records, my lord. Subsequently, they brought it, but this is not a 48 notice. My lord, one thing is there, my lord, it should be seen by the magistrate, my lord. That seal and symbol is, lordship will never find that. It's a all fabricated documents.
You may make such submission on
Yeah.
Monday.
Monday. Just I'm just pointing out. Monday.
Lordship may call for the.
The record is there. In the record, it is not
Lordship call
available.
for the 47, 48 notice lordship if it is not there on record lordship.
Record না থাকলে কোথায় আনিব?
On Monday.
Call for lordship.
No, records are there. We have the,
It is not complete lordship.
How can it be? How?
oh,
how
okay,
it-
we'll decide on Monday.
But in this case, I am in custody for more than 3 years. All the persons from whom recovery was made, specific allegations are there, my lord. I have given at paragraph number 14. 1, 2, 3, 4 persons, the main accused, all have been arrested. And today, my lord, after all were granted bail, my lord. I have given the chart at page 13, paragraph number 14. And the last order of one more will have also been granted bail, my lord. Your lordship will look at lordship's order, my lord. First, your lordship will look at paragraph number 14 at page 13.
Page
13, 1-3 of the bail petition.
Yes.
Now you'll also see this Thiagarajan and all those persons, I'll show from the complaint, their role. They have all been granted. The last one has also been granted. That is, I have given that is Krishna Mahapatra Malik. Now your lordship will kindly look at page 19, annexure 1.
Yes.
Now you're at annexure 1 at page 90, your lordship will find recovery of seizure of 10.276 methamphetamine crystal form on 7/3/2021 from the vehicle, that is Ford Fusion car bearing registration number so and so, from the conscious possession of Krishna Mahapatra. My lord, Krishna Mahapatra has been granted bail on 15/7/2025. Then your lordship will find 2, Mohammad Sofikur Rahman. Sofikur Rahman has also been granted bail on 22/5/2025. And my lord, the other accused also, my lord, I can point it out from the complaint. They have all been granted bail. I am the only person who is inside the bar.
What is your name?
My lord, I am Ramesh G. Your lordship will see
Ramesh.
accused number 8. And I have been arrested on the basis of this co-accused arrest statement who have been granted bail because in their CDR analysis, my phone number was found.
What is the date of your arrest?
Date of my arrest is, my lord, 14/3/2022. So 3 years, 5 months and 15 days in custody. The long incarceration is also there. There are other ground also, my lord. There are all those notices, 50 and all those are not, have also not been complied. But one good ground is enough to consider the bail application of this accused person. And out of the listed witness, my lord, till now,
How
only
many?
2 witnesses have been.
How many are listed?
15.
Page 74 is the witness.
Please. 71 is the witness list your lordship will find. Sorry, 74.
Yes.
74 is the list of witnesses, my lord. Your lordship will find 15 witnesses are there, and out of this only 2 has been examined. So it is not likely that a trial will be completed at the near future. Long incarceration, co-accused all granted bail. So your lordship has given them enough opportunity. They have filed their objection. It is on record. Your lordship will consider that objection and consider my bail prayer.
Lordship, we have filed our objection. Our objection may be considered, and lordship, regarding delay, lordship, yes, lordship, 2 witnesses have been examined out of 15. And lordship, he is the receiver of the contraband, lordship. Sufficient materials are there, lordship, bank account, air, flight ticket, CDR, everything is there. Flight ticket is also there, lordship. He is the receiver of the contraband. He came to Guwahati to receive, to deliver a contraband, lordship.
To receive or to deliver?
To receive, lordship. So sufficient materials are there, lordship. And lordship, one more submission, lordship, he is involved in another case, lordship. We have mentioned this in our objection, lordship, page number 140 in our objection. He is involved in another case, lordship.
Page number?
140 of our objection, lordship.
And in this case, another accused whose bail has been considered by the this honorable court, he is also involved in that case, but this court considered his bail application. Mariappan, my lord. M. Mariappan order, that is at page, it's BA number 1804. I'm pointing out the page, my lord. Last one. 126, my lord, M. Mariappan.
Heard Mr. B.D. Kaur, learned senior counsel assisted by Mr. H. Agarwal, learned counsel for the petitioner. Also heard Miss M. Deka, learned counsel for NCB. This application under section 483 of BNSS has been filed by the petitioner Ramesh B, who has been detained behind the bars since 14/3/2022, within bracket for more than 3 years, 5 months in connection with NDPS case number 131/2022.
I'm sorry, man, 21. Mistake. There's a typographical error, 21 months.
131/2021 under section 22C/29 of the NDPS Act, presently pending before the Court of Learned Session Judge number 2, Kamrup Metro at Guwahati.
Additional district and session judge number 2.
Yes. Additional Session Judge. The gist of accusation in this case, Code Para 3 from page 127 of the bail application. Learned counsel for the petitioner has submitted that in the final complaint filed by the NCB in the aforesaid case, 8 numbers of accused persons were shown therein. He submits that except the present petitioner, except
One more is there. He is also behind. He is not before. Kanetji.
except the present petitioner and one co-accused, Mr. Ganesh Ji, all other accused persons have been granted bail in the said case. He further submits that nothing was found from conscious possession of the present petitioner, and he has been implicated in this case on the basis of statement of the co-accused. He also submits that though the petitioner has been languishing behind the bars for more than 3 years, 5 months, however, till date, out of 15 listed prosecution witnesses in the final complaint, only 2 have been examined. He further submits that at this phase, there is unlikelihood of early culmination of the trial, and therefore he is entitled to get bail on the ground of prolonged incarceration. As due to such prolonged incarceration, his fundamental rights guaranteed to him under Article 21 of the Constitution of India has been violated. On the other hand, learned counsel for the NCB, Ms. M. Deka, has opposed the grant of bail to the present petitioner on the ground that quantity of contraband seized is is of commercial quantity, and therefore the embargo of section 37 of the NDPS Act is applicable to this case. He also submits that the petitioner was the intended receiver of the seized contraband, and he came to Guwahati only for the purpose of receiving the seized contraband. She also submits that there are sufficient materials on record against the present petitioner regarding his complicity in the offense alleged in this case. She has also submitted that the petitioner is also involved in
That your lordship will find at paragraph 4 at page 127, the same case number. Because I was also brought on the strength of the production one.
also involved in another case of similar nature, and therefore she opposes the grant of bail to the present petitioner. I have considered the submissions made by learned counsel for both sides and have gone through the scanned copy of the records of NDPS case number 131/2021. Then court para 9, 10, 11 from page 129.
We don't.
13, 14, 15, 16, 17, 18, 19, 20, 21, 21, not change the duration in 21. And 22, 1 lakh with 2 sureties of like.
Your lordship, kindly, for a moment, my lord, your lordship, kindly see paragraph number 2 my lord, of the petition.
2 of the
Petition, my lord. Page 3. Wife, my lord, she says that she sells chowmein and idli in the local area. I don't know whether they will be able to give 1 lakh or not, but still.
No, lordship, offense is serious in nature, lordship. He may jump the
1 lakh with 2 sureties.
With 1 shoot.
2 sureties. You are
Chowmein, his wife says that I sell chowmein and idli.
let us see if the
I leave it to your wisdom, but if I finish, if we can't, my lord, then we'll come for modification. We'll try to first convince them. Because normally, if a person is from the low income of the society, your lordships.
no, but considering
yes,
the
yes.
nature of offense.
Yes. Oblige you.
47. Lordship, one more prayer. In item number 45, I may be allowed to go for the record, lordship. If I find anything, lordship, I will flag my.
Item NJ Datta. Yes, you may go through the record.
Lordship, 47 may take up after 48, 40, 48 senior.
48,
Sir.
no, 49.
14.
49.
14.
49 and 47 are similar.
Similar better. 49 are maybe.
In the 49, if your lordship take first.
49
an additional affidavit. My lord, I have a special prayer in that. My lord, the lordship is aware regarding the case of Arvind Kejriwal.
My lord, the division bench of the Honorable Appeals Court, by order dated 13/9/2024, granted bail to Mr. Kejriwal for campaigning, just for political campaigning to reach out to the people, I mean, to the voters. Now here, in this case, my lord, you'll also will find the petitioner, my lord, he has filed an application for candidature on 14/2/2005 for MCLA election. MCLA means Member of Council of Legislative Assembly. And he has to file his nomination on 2nd September, my lord.
MCLA.
MCL, yes, Member of Council Legislative Assembly. Now, he has to file his nomination on 2nd of September, 2025. So it is mandatorily, the requirement of law is that he has to be present, because there will be scrutiny and all that. So therefore, under that circumstances, my lord, I am praying that at least your lordship for 20 days or for 3 weeks, if he can be enlarged on bail as an interim measure. And after that, we shall file our further report.
What is the offense?
Offense, my lord, I am in the, I am not the name in the FIR. I'll take your lordship to that. Lordship can see at page 13. ma'am. One Pankaj Pegu is involved. Ranjan Pegu at page 13.
Where this election will be held?
That is this borderland. I've specifically stated in my affidavit in paragraph 3, there are 3 men at page 21.
Yes. Anything else? You are only seeking interim.
My lord, for the time being, my lord, if your lordship, after seeing the case diary and all that, if your lordship is convinced that I am entitled to get bail, because your lordship.
No,
will
but
find-
it is fixed for hearing today.
Yes,
We can finally dispose it of.
and yes, my lord, your lordship can do that, but then if your lordship can see that this is a constitutional right of the petitioner. So, my lord.
No, why you are seeking for interim?
Interim,
Suppose
my lord,
if you
in
are
case-
found entitled to get bail,
Then it's fine, my lord.
but if you have to be ready for otherwise also.
But, the question is, my lord, if your lordship thinks otherwise, then if I am not getting any bail in that case, I'll be in trouble, because my constitutional right will be in jeopardy. I will not be able to file my nomination, my lord. And this chance will not come, because this is election for 5 years.
Okay, yes.
My lord,
Any other submission?
For the time being, this much, my lord, the subject to what.
He is not named in the affair.
not, my lord has already gone with this case diary, my lord. My lord, fact is that regarding those water resource department fake appointment letter issued and some persons, my lord, collected
Took
money.
money.
My lord, already I have earlier, we have submitted, my lord, I am recalling all this, my lord. There are 2 groups. And my lord, some persons, my lord, procured the fake certificates and given to one person, and those persons circulated it and collected money. Now there are groups, my lord, some persons are, my lord, they are also the, my lord, candidate, but collected money from their colleagues and different candidates. That is one kind of person. Some are, my lord, they are the brokers, they collected money is huge quantity. Now there are 2 groups. One is Abu Hanif Zakaria Ahmed, that one-sided group. One group is this Ranjan Pegu, Suniti, and Shankar, this one another group, my lord. Now this Shankar Kumar Bhomik, my lord, he my lord, appeared himself as a, my lord, officer of the Dr. Basam, my lord, one department. And few my lord, accused, they in their statement stated that Ranjan Pegu stated that he will obtain those certificates from one officer of the department, that is Shankar Kumar Bhomik. He himself projected as a departmental person, my lord. And now, and in the statement of Ranjan Pegu also stated that, he also stated that Bhomik
make those fake appointment letters and supplied to me through WhatsApp and all this. I am making printout and given to the persons. So ultimately, he is one of the mastermind along with this Ranjan Pegi group, my lord. He, in his petition, he stated that he is a contractor on what he has stated in paragraph.
You have already submitted your nomination.
No.
It is on, we candidature application has been filed. Nomination will be filed on 2nd September.
What is the process? First, you have to file candidature application.
Candidature.
Before?
then After that, my lord, there will be scrutiny in all that. Then on 2nd September, it will be filed and it will be scrutinized. My lord, the affidavit also has to be shown. Therefore, his personal appearance is a mandatory. Otherwise, it will not be considered.
Will finally dispose it on. What is your submission regarding his?
Personally, my lord, one person can be, my lord, his affidavit can be procured, my lord, from the jail also itself. His advocate may represent, my lord.
No. My lord, that's not correct position.
Yes, but he has to
Even in
submit.
the assembly election also, my
He has
lord,
to
I have
submit.
scrutinized many of the candidates.
Yes,
My
he
lord,
has
they
to-
are required to go there personally along with their advocate.
Otherwise, on merit, what is your submission?
My lord, merit, if your lordship look at the FIR, I am not named FIR. Now, how I am, if I am really implicated, that's the question of whether the trial will take care of it. If I am involved, it's okay. The question is, my lord, at this stage, my lord, the custodial investigation, all these things are over. And now the trial will take its own course. Now we are just praying for a bit.
Because, my lord, earlier there is an AB of this.
Since when you are behind the bars?
My lord, it
18
will
days.
be on, I was arrested on 12th, no?
10th
10th August. Today, now it is 17.
18 days.
17 days, 18 days. huh?
Okay, heard. Mr. S. Dr. Learned Senior Counsel, assisted by Ms. T. Som, Learned Counsel for the petitioner. Also heard Mr. K. Parashar, Learned Additional Public Prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shankar Kumar Bhaumik. Shankar Kumar Bhaumik, who has been detained behind the bars since 10/8/2025 in connection with CIDPS case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNS. The gist of accusation in this case is that on where is the affair?
At page 13, your lordship.
On 10/2/2025, one Bhaskar Jyotish Sharma, Chief Engineer, Water Resource Department, AWC, Guwahati, had lodged an FIR before the Additional Director General of Police, CID, Assam, inter alia alleging that certain miscreants are circulating fake letters with forged signatures of the informant to various divisions under Water Resource Department. Stop. Learned Senior Counsel for the petitioner has submitted that the petitioner has not been named in the FIR and he is in no way involved in the offense alleged in the FIR. However, he has been arrested in this case on 10/8/2022. He further submits that the petitioner is intending to contest election in ensuing BTC elections in forthcoming Boroland Territorial Council within bracket BTC election, and as he has submitted his candidature for the same, he further submits that the date of filing nomination paper for the said election is on
2nd September.
2nd September, and for the said purpose, he shall have to be personally present before the returning officer. Before the
That is the BTC Borderland Territorial Council.
before the concerned authority. He submits that if petitioner is not granted bail, he would be deprived of exercising one of his most valuable democratic rights. He further submits that the petitioner is ready to cooperate in trial, in the investigation, and therefore he submits that petitioner may be allowed to go on bail. On the other hand, Mr. K.K. Parashar, learned additional public prosecutor, has submitted that, has produced the case diary of
ADPS case number 4.
ADPS case number
04/25.
04/2025, and has submitted that there are sufficient implementing materials in the case diary against the present petitioner, which does not justify his release on bail at this stage. He submits that the petitioner impersonated himself as one of the officials of government of Assam, and what he did after.
He supplied fake appointment letter to Ranjan Pegu, and Ranjan Pegu also stated that he has got.
And it is he who had supplied fake appointment letters to one of the co-accused, Ranjan Pegu. Stop. You give me the case diary. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which has been produced before this court. Stop. I'll pass the orders in chambers after going through case diary. If suppose, what is your submission? If materials are there which do not justify grant of bail.
Because I am saying, because of only 18 days, his part, investigation.
No, my query is different.
Regarding this, filing nomination.
Whether any interim relief can be granted.
I have leave it to Lordship.
Okay. No, I have not gone through the case diary. Let me see the case diary.
Definitely.
I'll pass order in the chamber today itself.
Much of it.
And what happened to 27? 47?
47 my learned friend.
Yes.
Suniti Das.
That's idea rejected. Now it is 52 days.
How many days?
52 days. Like 7 years punishment, so maximum 60 days. May I pray that any condition local?
Regarding her, she has collected money from the individuals, from the candidates, and given the money to the Ranjan Pegu. Yes, she has collected.
Duped me. That is my case.
Ranjan Pegu is?
Duped me.
Okay.
My sisters, for my sister, for my friend.
From several persons. There are statements from several persons. She collected money. She collected money and given
even
to
for my
Ranjan Pegu.
sister also, own sister.
Where
But
do you
rega-
stay?
But
Morigao.
Morikawa Lordship, very adjacent to Guwahati Lordship.
comparing to that other case, he procured and supplied those documents, but he collected money.
Heard Misty from learned counsel for the petitioner. Also heard Miss, where is the rejection order?
At page 20.
Also heard Mr.
24.
A.K. Parashar, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Shunti Das. Shunti Das is male or female? Shunti Das, who has been detained behind the bars since 5/7/2025, within bracket for last 52 days in connection with CIDPS case number 4/2025 under section 61 within bracket 2/318 within bracket 4/336 within bracket 3/340 within bracket 2 of BNS. The gist of accusation, quote para 3 from page 25. Learned counsel for the petitioner has submitted that the petitioner was having business relationship with one Ranjan Pegu, who is also one of the co-accused in this case. And it is he who duped her and her sister, duped the petitioner and her relatives on assurance of giving grade 4 work charge job to them in the Water Resource Department. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars for last 52 days and all the offenses involved in this case entails punishment not more than 7 years, and therefore under section 487 of BNSS, the maximum statutory period of detention in this case is 60 days only. Hence, she prays that the petitioner may be granted bail on the ground of period of detention undergone by him. On the other hand, learned additional public prosecutor has produced the case diary of CADPS case number 4/2025 and has submitted that there are incriminating materials in the case diary against the petitioner. And there are evidence to show that the petitioner collected money from other prospective candidates also and paid the same to the co-accused Ranjan Pegu. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the records of the case diary of CADPS case number 4/2025. Though there are sufficient materials against the petitioner in the case diary, however, considering the progress of the investigation in respect of the accusation leveled against the present petitioner, as well as the fact that the petitioner has already undergone 52 days behind, already completed 52 days behind the bars. This court is of considered opinion that if the petitioner cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation in CIDPS case number 4/2025. In view of the discussions made in the foregoing paragraph, the petitioner, Shri Shunti Das, is hereby allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the learned Chief Judicial Magistrate, Nalba, Kamrup Metro, with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
I'll give you.
Item 14.
May I please, your lordship? My lord, this is second application earlier rejected on 4/8/2025. My lord, today is 84 days, my lord. My lord, offense under section 3(1), section 5, FIR, my lord, on page number 16, my lord.
Where is your earlier rejection order?
My lord, on page number, my lord, 23, my lord.
What is your case?
My lord, that allegation is that he's a bank employee, my lord.
No. Why are you seeking bail?
My lord, I am behind the bar for last 84 days,
So
my lord.
period of detention.
My lord.
And
my lord,
anything else?
Anything else is also there, my lord. I have become a scapegoat, my lord. I'm not manager or assistant manager of that particular bank, my lord. I am customer relationship officer. '84 from 6, including today.
Otherwise, his duty was to compare KYC. Okay. Heard Mr. R. Sharma, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner Dhiraj Kalita, who has been detained behind the bars since 6/6/2025, within bracket for last 84 days, in connection with Mushalpur PS case number 38/2025 under section 316 within bracket 5/3 within bracket 5 of BNSS. BNS read with section 66C/66D of Information Technology Act. The gist of accusation, quote para 3 from page 24 of the bail application. Quote para 4, quote para 5, quote para 6. Learned counsel for the petitioner has submitted that the petitioner is only an employee of the bank and he has been made a scapegoat in this case. He further submits that the petitioner has been detained behind the bars since last 84 days, and considering the period of detention, there is a likelihood that investigation might have been progressed and there may not be any necessity for further custodial detention, and therefore he prays for allowing the petitioner to go on bail. He also submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Mushalpur PS case number 38/2025 and has submitted that there are sufficient incriminating materials against the petitioner in the case diary. Stop. However, he submits that the investigation with regard to the complicity of the present petitioner has fairly progressed, as his specimen signatures have been obtained and have been sent to forensic laboratory for examination. And it is pending for, and the report of the forensic laboratory has not yet been received. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which was produced by an additional public prosecutor. It appears that there are incriminating materials against the petitioner in the case diary. However, the investigation as regards the complicity of the present petitioner in the alleged offense has fairly progressed. Further, considering the fact that the petitioner has been detained behind the bars for last 84 days, this court is of considered opinion that if he cooperates in the investigation, his further custodial detention may not be necessary for fair completion of the investigation of the aforesaid case. So in view of above, the above named petitioner is allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of learned
Chief Judicial Magistrate, Baska, Masalpur.
Chief Judicial Magistrate Baksa, Musalpur, with following conditions, number 1 and number 2. Send back the case diary. This bail application is accordingly disposed of.
Deeply obliged.
Before the adjournment portfolio.
Yes, that condition is there, 1 and 2.
Obliged.
Also the case diary.
Case diary is there.
Last occasion also case diary was not there, my lord.
You are on interim.
No, no, while I'm on interim, my lord.
The CD has not been received, lord.
My lord.
We have sent back for updation.
One order, my lord. The prime accused, my lord. Prime accused is Brijesh Kumar Parnal. He has already been enlarged on bail, my lord, after going to the city.
No, whether you have complied with the
Yes, they have appeared before that. I was and are totally interrogated, madam. They substantially progressed, madam. And the prime accused has already gone enlarged on bail, my lord. Plus the order, my lord. He is the offense to the manager. The particular bank. Initially, he was granted interim and thereafter.
He's already on interim also. The date may be fixed, will produce the case diary and then also.
Okay.
Accused has already been enlarged on bail. What will be
Okay,
that?
no, you are on bail. Let us peruse the case. Heard Mr.
That's what.
S. Bora, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor, who prays for some more time for producing the case diary. Prayer is allowed. Let this matter be listed on 15th of September. The interim order shall continue till next date. You can take back this.
May it please your lordship. My lord, in this case, my lord, CG was called for and the interim order bail has been granted. And in last occasion, my lord, CG was produced and ultimately time was short for getting the up-to-date my lord, the case diary.
My lord, CD receipt, my lord. Here, my lord, there is a meeting
And
question
the
that
two
stands
accused has
for
been granted
FSL,
to-
my lord. And my lord, other Caesar witness, my lord, stated that he is a owner, my lord, from where it is, my lord, recovered. Other than that, my lord, he appeared, my lord, before the police stations after getting the interim.
And my lord, the two accused has been granted bail by this honorable court, my lord. And in fact, my lord, we have stated in our petition that he is a broker, my lord. He used to broke in the market
Okay.
in selling and purchasing.
Heard
these-
Mr. M. H. Chaudhary, learned senior counsel assisted by
Hassan Ahmed.
S.N. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Bushra, learned additional public prosecutor. Learned senior counsel for the petitioner has submitted that the petitioner, what is the name of the petitioner?
Saiful Islam.
Petitioner, namely Saiful Islam, was granted interim bail with certain conditions by this court on 28/7/2025. Stop. He submits that in pursuant to the order of this court, the petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. On the other hand, Mr. K. Bushaw, learned additional public prosecutor, has produced the case diary of Nagaon PS case number 520/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement
Statement not recorded, madam, but his appearance was.
he has appeared before the investigating officer. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary. Stop.
Otherwise, madam, his implications are there. That is-
Though there are implicating materials against the petitioner or in the case diary. However, as he has complied with the directions of this court and has cooperated in the investigation, the interim bail granted to the above named petitioner by order dated 28/7/2025 is hereby made absolute with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipated bail application is accordingly disposed of.
Highly obliged.
CD not received.
CG has not happened.
You are on interim.
No, my lord, I'm not.
When CD will come? Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. K.K. Das, K.K. Parashar, learned counsel, learned additional public prosecutor who submits that, who prays for some more time for producing the case diary. Prayer is allowed. On perusal of the office note dated 19/8/2025, it appears that though notice to respondent number 2 has been issued, however, service report is still awaited. Learned additional public prosecutor is requested to take information regarding service of the notice upon respondent number 2 from the officer in charge of concerned police station and let this court know about the same on the next date fixed. Let this case be listed on 11th of September.
May please, your lord. This case
29,
lordship from 29, 30, 31, 32, 30.
29 to 33, 35, 36, 37.
And 37, I am not there, lordship. I am up to 36.
Before my lord, senior starts, my lord, one thing is that my lord, service, in all the cases, service report we have, my lord, we have received from the, all these cases, my lord.
Proxometer.
Yes, POXO is there.
All are proxometer.
POXO section is there and but last occasion also because
My
of the,
learned friend after the CD has said that there is nothing against me at least. Probably.
but last occasion when matter is reached, my lord, regarding the service, that question can arise. Otherwise, now
Otherwise,
service.
lordship, he has from the CD.
No, yes, we have no POXO against this person, my lord. POXO against other, but section is there.
Should the others come, then let's say between.
What is the case? What is the?
Lordship, lordship, the
You are appearing in item number 29 to
29 to 33, then 35 and 36.
except 34.
No, except 37.
34 is not connected.
34 is not connected, lordship. Somehow in between it has come, lordship. 34 has nothing to do.
34 already adjourned.
Yes, 34 to no.
34 mention করেছে. Yes, what is the case?
Lordship has granted the interim order and the, as per the
Interim has
order,
been
lordship-
granted. To all of them.
Yes. And the accordingly, Lordship, I appear before the IO, this petitioner on 29/7, Lordship. Lordship has passed the order on 28/7. And to that effect, Lordship, I have filed an additional affidavit, Lordship, in the item AB 178025, Lordship. The Lordship has given me on 28/7/25.
In all cases.
Yes. No, not in all cases. Lordship, not in all cases. Not in all. In the interim order dated 28/7/25.
They have appeared.
Okay.
All of us.
Then we'll make
No,
it abs-
there are matters, that the projection, if senior, let me, let
Yes.
finish.
I have nothing to hear, Lordship. The Lordship can see the affair.
We are taking up item number 29.
Yes, Lord. Lordship is.
But one thing is that I am clarifying, the incident how occurred, both these several persons, they have different roles, in the whole incident, so I have to come chronologically with that incident, how it occurred and what is the role played by these persons. Some few persons have actually not such, but 3-4 persons are. I have
my learned training clear.
So we'll take one by one each case.
Yes. That can be, but otherwise, if senior argued, order may be in different way, but I have to argue, I have to start from 37 because start from him,
Lordship, let him, because I have the first item number 29, Lordship. Lordship will take note. Says an OT nurse, operation theatre nurse. So because I have to place it like that, because my learned friend is very correct, because everybody has a different role. So let me say, Lordship, in the item number 29, this itemony
In
maze.
all the cases, interim was granted.
Yes.
Interim.
All of them have appeared.
All of them have appeared.
Now you have
Now-
some reservation against some.
Yes,
day.
yes, person.
You want their interim bail to be vacated.
Yes, because one girl, that delivery was done in a hospital, and being the doctor, being the director, and all this, we have done the treatment. That was the submission, and because of that, once granted to one, someone is nurse, someone is pediatrician, so ultimately all were granted. And at that point of time, CD was not before us, so FIR is only that, and POXO is not against them because of interim to all. Now different things has come
Stories
out.
emerging. Okay.
So let
Yes.
me place the order first.
Yes,
Lordship.
yes.
Order, Lordship will clear the on 28/7/25. Lordship has recorded everything, Lordship, in the order. From para 3. The gist of acquisition in this case is that on 16/7/25, one Vijay Kharia, who claimed himself to be the Gaon Pradhan of Village 1, Kasamari village, had lodged an affair before the officer in charge of Moran police station, Interim, alleging that the victim girl, who is a minor, have gone.
That counsel for the petitioner. Learned senior counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail by this court on 28/7/2025. And in pursuant to the directions of this court, she has appeared before the investigating officer on 29/8/2025 and has cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Moran PS case number 75/2025 and has submitted that the petitioner has cooperated in the investigation. No, petitioner has appeared before the investigating officer and her statement has also been recorded under section 180 of BNSS. Stop. Considering the fact that the petitioner has complied with the directions of this court, the interim bail granted to the above named petitioner by order dated 28/7/2025 is hereby made absolute with condition number 1 and 2 attached to the same said order remaining intact. This bail application is accordingly disposed of. Send back the case diary.
My lord, for simplify the my lord, all matters, my lord, may this order can be also be passed regarding item 31, Marine Saikia. 31. 31 Marine Saikia is a pediatrician, my lord. And 33, Hafizur Rahman, Managing Director. Pediatrician, my lord, after the delivery of the baby.
When they appeared on the same date.
1/8. Marine Saikia on 1/8 and Hafizur Rahman.
Same order, date of appearance 1/8 and Hafizur Rahman 1/8. The rest is same order. 29, 31 and 33, same order. Item number 30.
Item number 30 is the recovery room nurse. So she recovery room nurse, and she has appeared on 29/7/25. So in this case, I have filed an additional affidavit.
What is there in the additional?
Yeah, that is what I. Please come to page 68.
Yes.
To the Senior Superintendent of Police, Dibrugarh, also on 30th of July. Because on 29th, she went to the police station. And then on 30th of July, she has written this letter to the Senior Superintendent of Police. Refusing to acknowledge the receipt of the Honorable High Court order. This is to inform you that by the order dated 28/7/25, passed in AB number 7, the Honorable Guwahati High Court was pleased to grant protection of interim period to bail. The undersigned in relation to the above referred affair. Please find enclosed here in the said order for your kind perusal, and the contents of the said order are self-conscious. Yesterday at 2:10 PM, in compliance with the direction of the Honorable High Court, in the said order, the undersigned had appeared before the IO of the above referred affair SI Manasjuti Pathak at Moran PS. The said IO was not present at the PS at that time and reached the PS at 3:30 PM. Thereafter, the IO spoke to the undersigned and Ms. Aitumani Math granted pre-arrest similarly in AB number so-and-so by the Honorable Guwahati together. During this conversation, the undersigned informed the IO about the aforesaid order being passed and provided him with the printed scanned copy or the certified copy of the said order along with the forwarding letter. After the IO took the said letter and the order, the undersigned requested him to sign and receive the same on a copy of the said forwarding letter. At this juncture, the IO threatened the said undersigned, "Tohator MD sare High Court kini lole neki. Iman joldi bail order ulai loise je eko receive kori nidiu tohatok." Further, during the meeting, the IO forced both the undersigned and Mrs. Das to sign one document each without informing the undersigned and Ms. Math what document is that, and without permitting them to read the contents of the same. No copy of the said document was provided to the undersigned either. Such conduct on the part of the above named police official has now led to the undersigned to approach arbitrary and high-handed action on the part of the in relation to the investigation above referred affair. And Lordship, I have to show Lordship the two things. In the meantime, Lordship, during the investigation and the Lordship, there is an order at page 63, Lordship. The main accused is arrested. Father of the respondent number 2. He was arrested. And then
who is main accused?
the father of the respondent number 2. Respondent number 2, that's that girl's father. Other accused is also arrested.
Father is the
No.
And the other accused is also arrested.
That
The man He was, yeah, he was also arrested.
Yes, sir.
Yes, sir.
The person against whom POXO charges were.
Yes, sir.
Yes,
Yes,
sir.
he was also arrested.
Both of they were.
Both of them, father.
Yes, yes, father was because that he sold the baby to one person.
Yes,
Because
that-
of that,
Yeah,
father
yes,
came out.
that is
Okay.
Main allegations are.
So main allegations are against both of them, and both of them were arrested and they were behind the bar. So that is what I want to show Lordship, that page 63.
One baby.
And
is
the
also
newborn baby has already been recovered. That is there.
Yes, 28/7/2025. And in pursuant to the directions of this court, the petitioner had appeared before the investigating officer. However, when she appeared before the investigating officer on 29/7/2025, the investigating officer, namely Manojyoti Pathak, SI, refused to accept the copies of the order of this court and passed certain derogatory remarks against the High Court. Learned Senior Counsel for the petitioners further submits that later on, the investigating officer took signatures of the petitioner on which paper?
In the blank paper.
On blank paper, without informing her as to on what document signature is obtained. The Learned Senior Counsel has also submitted that in this respect, on 30/7/2025, the petitioner has lodged an FIR, lodged a complaint regarding this incident to the Senior Superintendent of Police, Dibrugarh. However, nothing has been informed regarding any action taken by the Senior Superintendent of Police in this regard. On the other hand, Learned Additional Public Prosecutor has produced the case diary of the Moran PS case number 75/2025 and has submitted that the statement of the petitioner has been recorded by the investigating officer. He also submits that the petitioner, who is a recovery room nurse, has also been, who is a recovery room nurse, is also involved in the offense alleged in the FIR. He further submits that there is a nexus between some of the other accused persons in falsifying the documents and demanding excess money from the victim for conducting her delivery. Stop. I have considered the submissions made by Learned Counsel for both sides and have gone through the case diary of Moran PS case number 75/2025. Though there may be some incriminating materials against the petitioner in the case diary. However, it appears that in pursuant to the that she has complied with the directions of this court and has appeared before the investigating officer on 29/7/2025 and has cooperated in the investigation. Stop. As the petitioner has complied with the directions of this court, the interim anticipatory bail granted to her on 28/7/2025 is hereby made absolute, and he is hereby made absolute subject to the with condition number 1 and 2 attached to the said order remaining intact. Stop. As regards the allegations leveled by the petitioner by filing an additional affidavit against the investigating officer, Mr. Manojyoti Pathak, is concerned, this High Court takes serious note of the same, as derogatory remarks have been passed against this court. It also appears that the petitioner has already filed a complaint to the Senior Superintendent of Police Senior Superintendent of Police, Dibrugarh, complaining about the same. The fate of the said complaint is not known. Hence, the Senior Superintendent of Police, Dibrugarh, is directed to submit a report before this court within 15 days from the date of this order, intimating this court regarding the fate of the complaint filed by the petitioner, Miss Anita Das, to him on 30 July 2025. The report may be furnished to this court through the office of the public prosecutor. The said report shall reach this court 15 days time due on or before 18th of September. This
A copy of the order maybe, my lord.
yes, let a let a copy of this order be furnished to the learned additional public prosecutor so that he can communicate the same to the Senior Superintendent of Police at the earliest. Let this case be listed again now. Though I have made absolute, I am not disposing of the case. Let this case be listed again on 18th of September.
Next is item 32. Lordship,
yes,
my learned additional PP has placed everything, and against the Rashid Parvez, he has given all the allegation and the now whatever he said. Let us see directly, Lordship. My client appeared on 1/8/2025 as per Lordship's order. Now he had been called to the police station once, twice, thrice, all right. Then Lordship may please come to page 88, my additional affidavit. Let's see whether these things are there or not. One should be very careful, Lordship. My learned additional PP is very, I know. Page 88. Page 88, Annexure 17.
Yes, what is this?
Lordship, get it. This is a notice under section 94 of the BNSS, the earlier 91 CRPC notice, Lordship.
Yes.
So the first question, Lordship, let us see. This is on 12/8/2025, Lordship. Undated, but I received it on 12/8/2025, Lordship will note that. 12/8/2025. It is signed, sealed, everything is there from the IO. IO has signed. Now, Lordship, this is the interrogatory. No way these things were suggested. What my learned friend has now said from this case diary. Not a single word, not a single whisper that you have some here.
Illegal questions.
Secondly, my lord, this
No, no.
question whether he can ask.
Just a minute. In the earlier case, a copy of order shall be furnished to the learned additional public prosecutor.
Yes.
Along with the copy of additional affidavit filed by the petitioners. Along with the copy of additional affidavit filed by the petitioner on which.
On which day?
Otherwise, the.
My lord, on 28, Lordship, we have filed.
On 28.
208.
Okay, yes. No, in this case, notice under section 94 was given.
Yes.
What do you want to submit?
I want to submit, Lordship, all this has been now, Lordship, the additional PPS said the some allegations. These question, Lordship.
1, 6 and 7 last.
Lordship, for a moment, Lordship, CD, question number 1. Whether a IO can ask a person,
under 94.
he is not a doctor, he is not a and the asking for law. The detail of document mandatory required to provide a birth certificate as per procedure of law. Now he is
How can you ask under 94?
under 94, Lordship. Now, Lordship may please come 6 and 7.
Last 2 questions.
As per form fill up by the Brahmaputra Hospital, birth report imani newborn baby, so and so. Reason for no name informant, mention the location document, district Moran, state of Dibrugarh.
Yes.
The Lordship, in my page 92, it is very specific. I have given the reply, I'll show that. Then 7, mention the region of issued uploaded the birth certificate without collection of mandatory document from the parent, without document verification, even the patient has been.
Yeah, stop. On the other hand, learned additional public prosecutor submits that has produced the case diary of Moran PS case number 75/2025 and has submitted that though the petitioner has appeared before the investigating officer and his statement under section 180 of BNSS has also been recorded. However, there are incriminating materials found during the investigation which indicates his complicity with other accused persons in commission of the offense alleged in the FIR. He submits that there are sufficient evidence on record indicating that the documents were falsified and additional money was demanded.
Taken, 50,000 taken.
Was taken from the victim for conducting the delivery of the victim. Stop. You need custodial interrogation.
Malad, yes, only because of Malad, in the statement also he has stated that such type of case come to our office, our office, and we are doing this practice is doing this.
Learned additional public prosecutor also submits that the custodial interrogation of the present petitioner is required, as there is indication that in similar other cases, the falsification of documents and demanding of additional money for conducting delivery have been reported. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary which has been produced by the petition learned additional public prosecutor. It appears that in pursuant to the directions of this court, the petitioner has complied with petitioner has appeared before the investigating officer and has cooperated in the investigation. Stop. Though there are allegations, though there are materials indicating to the complicity of the petitioner in commission of the alleged offense, however, there is no indication that he has violated court's order, or there is no material on record to suggest that he is not cooperating in investigation. Under such circumstances, this court is of considered opinion that if the petitioner continues to cooperate in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation in Moran PS case number 70/2025. For the aforesaid reasons, the interim bail granted to the petitioner by order dated 28/7/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This anticipatory bail application is accordingly disposed of.
Steps on.
35.
35 49 as asked by Amita Das that Parvez Rashid and
He used to
Dr.
take more money.
No. He receives he sends the date as asked by the employer as 20 years. He put the in the
Falsifying the
Yes.
record.
Yeah.
But Mr. Likibo, same counsels now. Learned senior counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail on 8/8/2025. On 8/8/2025, and in pursuant to the directions of this court, he has appeared before the investigating officer on 12/8/2025 and have cooperated in the and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Moran PS case number 75/2025 and has submitted that he has appeared, that the petitioner has appeared before the investigating officer, and his statement has also been recorded under section 180 of BNSS. Though however, learned additional public prosecutor submits that there are incriminating materials in the case diary indicating to his complicity regarding the falsification of documents in connection with the offense alleged in this case. Stop. He therefore, you are opposing. Falsify, stop. I have considered the submissions made by learned counsel for both sides and have gone through the case diary of Moran PS case number 75/2025. It appears on perusal of the case diary that the petitioner has appeared before the investigating officer and has submitted and has cooperated in the investigation and thereby complied with the order of this court. Though there are some incriminating material against the petitioner in the case diary, this court is of considered opinion that if the petitioner continues to cooperate in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of Moran PS case number 75/2025. In view of above, the interim bail granted to the petitioner by order dated 8/8/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. Dispose of, except one, all cases. Yes, this one is. He has appeared. He demanded money, extra money. Okay. Odds, same. No, but you are investigating this case, unless. Okay. The petitioner was granted interim bail by this court on 28/7/2025, and in pursuant to the directions of this court, the petitioner has appeared before the investigating officer on 1/8/2025 and has cooperated in the investigation. Stop. On the other hand, learned additional public prosecutor has produced the case diary of Moran PS case number 75/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement has also been recorded. However, he submits that there are incriminating material in the case diary to indicate his complicity in the offense of falsification of the records alleged in the FIR, as well as offense alleged under Section 80 of Juvenile Justice Care and Protection of Children Act. Stop. I have considered the submissions made by learned counsel for both sides and have perused the case diary of Moran PS case number 75/2025. It appears that the petitioner has complied with the directions of this court and has cooperated in the investigation. Stop. His submission has, his statement under section 180 CR 180 BNSS has also been recorded by the investigating officer. Stop. It also appears that there is no indication in the case diary that there is any resistance on the part of the present petitioner in assisting in cooperating with the investigation. Stop. Hence, this court is of considered opinion that if the petitioner continues to cooperate in the investigation, his custodial interrogation may not be necessary for fair completion of the investigation of this aforesaid case. In view of above, the interim bail granted to the petitioner by order dated 28/7/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. This bail application is accordingly disposed of. 37. He referred the girl to the hospital. Falsifying. You have appeared before the IO or not? Both of you. Okay. Heard Mr. M. Colley. False. Heard Mr. M. Kolita, learned counsel for the petitioners. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application, learned counsel for the petitioners has submitted that both the petitioners were granted interim bail by this court on 8/8/2025, and in pursuant to the directions of this court, they have appeared before the investigating officer and have cooperated in the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Moran PS case number 75/2025 and has submitted that the petitioners have appeared before the investigating officer and their statements have also been recorded under section 180 CRPC, 180 BNSS. He, however, submits that there are sufficient incriminating materials against petitioner number 1, that is Dr. Simanto Jyotitai, of having been involved in the falsification of records, as well as the offense alleged in this case. Stop. I have considered the submissions made by learned counsel for both sides. On perusal of the case diary, it appears that the petitioner has appeared before the petitioner has complied with the directions of this court and have cooperated in the investigation. It also appears that there is no indication in the case diary that the petitioner has not cooperated in the investigation. Considering the above facts, this court is of considered opinion that custodial interrogation of the petitioner may not be necessary if they cooperate in the investigations. Hence, the interim bail granted to both the above named petitioners by order dated 8/8/2025 is hereby made absolute, with condition number 1 and 2 attached to the said order remaining intact. Send back the case diary. This bail application is accordingly disposed of. Stab injury is not there. No, but who said you stabbed? Record sound. Pick the oak. You point out. You see the medical report, injury report, postmortem report. Whether any stab injury is there. No, read the cause of death again. Okay. Which witness? You have gone through medical report, postmortem examination. Is there any indication of stab injury?
ইয়াছিল টিউচনলৈ যোৱা অৱস্থাত হাছান আলী মোৰ ঘৰৰ পৰা আবুল জাবেদ জাকিয়ে ফাল্লু ওলাই আহে আৰু আলিম জাকিৰ আৰু ফালুৱে মোৰ ভতিজাটোক মাৰিবলৈ ধৰে আৰু চিঞৰ বাখৰ শুনি মই দৌৰি ওলাই যাওঁ জাকিৰ once said that জাকিৰ আৰু ফালু নামৰ ল'ৰা দুটাই তাক কাঠৰ বাটেমেৰে মাথাৰ পিছফালে গলধনত মাৰে আৰু বুকুৰ তলত পেটত বাঁহৰত বেয়াকে কোবায় জাকিৰ আৰু ফালু নামৰ ল'ৰা দুটাই কাঠৰ বাটেমেৰে মাথাৰ পাছফালে মাৰে গলধনত মাৰে so
I'm showing to you not.
Ultimately, he cannot deny that he was present and he also assaulted the boy.
Fully participated.
And 3 days house search was made, Meladon.
Which my learned friend says that 2 persons assaulted the victim with pata. 1 injury was there. Who was that person? That is described by Shavali. That your lordship will say. Hey Kajia, মোৰ গাঁও বহুত কেইটা কুক পৰে মোৰ গাত বহুত কেইটা কুক পৰে আৰু এনেকৈ ঘোঁৰা মাৰামাৰি হৈ থকা এটা সময়ত জাকিৰ খানে হাতত থকা কাঠৰ বাটেমেৰে ইয়াছিনক পিছফালৰ পৰা মাথাৰ তলত মাৰে আৰু তেতিয়া সি বাগৰি পৰে পাছত ফালু নামৰ মানুহজনে পেটত মাৰি দিয়াত সি গুৰুতৰভাৱে জখমপ্ৰাপ্ত হয় so first in the head assaulted by the Zakir not by the present
but all these things will come in the trial, my lord.
And 3 occasions house search was made, my lord.
No, this is not a fit case for anticipatory bail.
10/11/24.
Though others have been, you have to surrender before the
at the time
trial
of
court.
the Zakir, my lord, it was not gone through, my lord. And regarding 3 occasions house search made, my lord. 10/11/24, 19/11/24, 20/11/24, and he was abscond as absconding. 10-11-24, 19-11-24, and 20-11-24.
Heard, Mr.
Their house search was made in respect of Zakir also. That is also there in
No,
the.
no, but how you are comparing everything? Who
Not
has
in
got?
Zakir got anticipatory bail.
After charge sheet, because he wanted to face the trial. And there was no committed court and lordship, that part.
Where is the order of the Zakir?
Page 47, it is nothing, no discussion, my lord.
Oh, dear lordship, just one thing I am pointing out that council may be different for the state, but the state is there. They cannot take two stands for the two persons who are in similar footing.
At the time of
No,
bail,
whether state did not oppose.
That was not opposed.
Our statement was not my lord, recorded, and
They have not even challenged this order. This application is pending since lordship.
so others should not,
My present.
so others should get the same benefit. Should not. You go to the trial court and apply there.
I mean, informant also did not challenge this order for the Supreme Court.
Which order?
And this bail allowing Zakir Khan.
No, but that would not give you benefit.
So this order lordship may kind of reasoning given for this.
Reasoning is in 5.
385.
No, but suppose you assaulted. No, Zakir had assaulted. Your submission is Zakir had assaulted. And Zakir got anticipatory bail. Suppose a planned murder was.
It is not a planned murder.
No, listen to my query. There is a planned murder and a person has been stabbed. And the petitioner and the accused remain evade arrest during investigation. Ultimately, charge sheet is laid. Then can he take plea that the committal court cannot grant me bail and I am ready to face trial, grant me bail if other materials are there?
I don't wait it. Because of lordship and the technical effects, subsequently others find. He did not. Now
given opinion.
Immediately after charges, he approached this court. He is not evading the process.
Fine. There is
only one.
No.
Assault part.
But special accusation, Zakir and you also.
Others also there. But in fact, also there is specific statement that I assaulted with knife and no knife injury is there.
No, these things
On
will
very
come in the trial, my lord. For bail, my lord, the whole trial will be completed.
In the case of Zakir, my lord, only one consideration was made, my lord. The petitioner submitted he is interested to face the trial. Only, my lord, not gone through the, my lord, the scan
The
copy.
trial appear, my lord, court will consider it according to law. That can be, we pray for that.
Paragraph 3 is also there that his apprehension was that if he appears there, he will be taken into custody.
No, he will not be.
In short, the petitioner has been charged in the session.
No, but for getting that benefit, you have to show your innocence.
Lordship, I fix it next Monday. Also, I will place some judgments also on. Similarly situated person. And in fact, he is in better position because that fatal blow was given by Zakir. There was a group fight. It is admitted by the witness also.
I am not in agreement with. Okay, let us fix it on Monday. Let him show the judgment. Heard. Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Parashar, learned additional public prosecutor. Also, as well as Mr. S. C. Vishwas, learned counsel for the informant. Learned counsel for the petitioner had on last occasion submitted that the petitioner stands on same footing with that of co-accused Zakir Khan, who has been granted anticipatory bail by a coordinate bench of this court on 4/2/2025. Stop. However, today, the learned additional public prosecutor has pointed out from record that there are materials to indicate that the petitioner had assaulted the deceased along with Jakir on his head as well as on stomach. Stop. Learned counsel for the petitioner submits that similar materials were there against the co-accused Jakir Khan, and he has already been granted bail by the coordinate bench of this court. He submits that on the principle of parity, the petitioner is also entitled to get anticipatory bail in this case. He, however, submits that, this court is unable to persuade itself with the submissions made by learned counsel for the petitioner at this stage. On this, learned counsel for the petitioner has submitted that he may be allowed some time so that he can produce some authority to show that the bail, to show what you will show. To show that on the question of parity, the decision taken by a coordinate bench is binding on this court. The prayer is allowed. Let this matter be listed on 1st of September, Monday. You can go through it. No, this trend is wrong trend. Otherwise, this court may not refuse anybody and the bar would stop applying certified copies. Therefore, what I am allowing is that you can go through the record during court hours at any time. Heard Mr. A.S.A. Ahmed, learned counsel for the petitioner. Also heard Mr. K. Bushaw, learned additional public prosecutor. They were directed to place track consignment. Putul, supplementary file, black white. No, it postal journal. Oh, it has returned back. Yeah, Calicut. On perusal of the office note dated. This is a POXO case. NI. And on perusal of the office note dated 26/8/2025, it appears that in respect of respondent, how many respondents are there? 3. Who- In respect of respondent number, what is the name of the no in yeah, Calicut. And it appears that the postal journal and track consignment report of the notice sent to respondent number 2 and 3 were placed before this court. Are placed before this court. However, same does not indicate the service of notice on the said respondents. In view of the above, you take fresh steps. The petitioner is directed to take fresh steps for issuance of notice upon respondent number 2 and 3 by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable after 4 weeks, list accordingly. No, you take fresh steps. List after 4 weeks.
Before this of the incident, even when there is no any time mentioned in the attempt.
Why this IA?
IA is, my lord, it is the objection file. Actually, it should not be come as IA, my lord.
Yes, it should have come in
Yes, my lord.
bail hearing.
Yeah, bail hearing, my lord, only there, my lord, objection, my lord. Somehow they filed as an IA, so it's come under order, my lord.
14427. Yes. Yes, CD is there.
CD is available, my lord. CD is available. Respondents has already filed
What
objection,
is
my
the
lord.
submission?
I think it's application against me is very late, my lord. Commit sexual harassment against 14 years down. My lord, Only the family dispute.
Okay, we'll go
I
through the,
appeared the police station 20th of April, my lord. Police
you are on interim bail.
Police called me. Appeared. He recorded my statement, my lord.
Yes, Mr. Bushaw. He's saying that everything is false.
But here, madam, may kindly produce the statement of the victim 180 and 183.
What she has stated.
Yes, madam. 183, the explanation of the act is there. Otherwise, in 180, the statement is the bear kam. It is read to Poxo method, but in 183, that explanation is there. And
she has alleged.
yes, allegation is there in both 180 and 183, my lord.
Yes.
And my lord, as per my lord, that is a police, my lord, collected one, my lord, school certificate, my lord, as per the date of birth is, my lord, that is 5/6/2011. On the date of occurrence, my lord, two